Sorry.
Yes, I think they didn't pay attention.
Thank you, Chair.
Yes.
Chair, my name is Isabel Goodman. I am here on behalf of Nedbank. I'm instructed by Alan Overy, and my attorney, Ms. Khan, is in the audience. Chair, Nedbank had brought an application on the 10th of May to adduce evidence and to be permitted to cross-examine Mr. Mohammadi in relation to the Transnet interest swaps. It submitted an affidavit on the 14th of June, and in January of this year, that application was granted. It was granted leave to adduce evidence and cross-examine. Nedbank, however, no longer seeks leave to cross-examine, and it seeks leave to have its affidavit stand as evidence before the Commission without the need to lead oral evidence.
Well, I'm quite happy to grant Nedbank leave. Must be leave not to proceed with cross-examination or to give oral evidence, but subject to one qualification, that the Commission retains the right at any time to call upon somebody at Nedbank to appear and avail themselves for questioning with regard to any aspects. So on that understanding, I'm quite happy to grant that leave.
Indeed, Chair, thank you.
Yes.
Nedbank has tendered both oral submissions and written submissions should the Commission require it, but it is a power, of course, you have anyway.
Yes, okay.
Thank you, Chair. May we then be excused?
You are excused, yeah.
Thank you.
Thank you. Yes, Mr. Pretorius.
Yes, Chair. May Mr. Mpofu address you?
Yes. Thank you.
Good morning, Chairperson.
Good morning, Mr. Mpofu.
Thank you. Chair, I'm here to address an application. I believe the Chair has had sight of a copy of our application.
Yes, I have had a chance to read the application.
Okay. We also prepared some heads, but I'm told they were not properly transmitted, but we'll rely on the application papers.
Yeah, okay.
It's quite a simple application.
Okay.
Thank you, Chair. Chair, if I may just clarify very quickly. Well, firstly, my name is Mpofu. I appear with my juniors, Ms. Pillay and Mr. Sboto, for Mr. Mkhesi. Now, the real reason we're here, Chair, is at a simplistic level, it's really just a postponement application. And in fact, and as I will explain now, it's two postponement applications, as it were, rolled into one. Because, as the Chair will have seen in the notice of application, we have two prayers in the alternative. The one...
Well, I don't know if I saw the notice, but I saw the affidavit. I don't know if I saw the...
The notice, okay, I'll read it out.
Yes, okay.
We asked for two prayers. One, that the applicant's obligation to testify at the Commission be and is hereby suspended until the finalization of any criminal charges against the applicant pertaining to the asbestos audit conducted in the Free State. So that's the main prayer, so to speak.
Yes.
Then we say alternatively, and that's why I'll explain that now.
Yes.
Alternatively, that the applicant's obligation to testify before the Commission is hereby stayed pending the finalization of a court application for a review, declaratory, and other appropriate, just, and equitable relief. In other words, Chair, the second prayer only arises if the first prayer is not
Fails.
Yes.
Yeah, okay.
And so, in theory, we could have done the first application, then we get a
Yes.
ruling, then we come back. But to save
Yes.
time, we do both of them back to back in anticipation. Now, so that's really what we want to clarify up front. All these other interesting issues about Section 35 and what have you are not directly before you, so to speak. We only raise them in order to justify the application for a postponement. So what's really before the chair is whether we have sufficient ground to ask for the postponement. Now, Chair, in our heads we had outlined the principles, but they are trite. About, there must be good cause, it must be a bona fide application, and so on. Asking for the postponement. And we are, in a way, fortified by the fact that the chair has already granted a postponement in this matter before, which we are very grateful about. And that postponement was particularly because by the time Mr. Mokgese had come here, at that stage, he had just consulted with his lawyers, and he had not really had a proper consultation. So he wanted an opportunity, which the chair
Wasn't there also an issue about his senior counsel not being well?
That was correct,
Yeah.
yes. So
That's the one I remember quite well.
yes, that's correct.
The
Yeah.
ground I
So
remember.
roughly, Chair, the point I'm really going towards is that postponement was really to afford him a chance to get proper representation. Which is related, as the chair knows, these are all Rule 35, Section 35 issues: the legal representation, the right to remain silent, the right not to incriminate yourself. They belong to the same family of rights, so to speak. Now, so what has actually happened, therefore, is that he now has obtained such legal advice, which is why we're here. And Chair, in a nutshell, we assert the rights that I spoke about, particularly the right to remain silent and the right not to incriminate yourself, in the following manner specifically. Put it this way, our quarrel is not with the Commission, because the Commission does not appoint itself and it does not draw its own terms of reference, so to speak. But unfortunately, the road to the other quarrel has to go past here, so to speak. So in a nutshell, Chair, I'm not going to go into the legal cases and so on. In a nutshell, what we're saying is that in asserting his right to remain silent and his right not to incriminate himself, in these particular circumstances, we concede up front that those rights, if you read the Constitution literally, they are accorded to what is called an arrested person or an accused person. And we concede that there is some grayness about that, because we cannot take it further higher than saying that he has been told that an arrest is imminent, so to speak, but in reality, he's not.
It hasn't happened.
Yes, it hasn't happened. That we concede. But I suppose we counter that concession very quickly by the chair knows very well that in terms of Section 38 of the Constitution, you may assert your rights even if they are merely threatened. In other words, even if the violation has not actually occurred. Secondly, the right against self-incrimination also extends to the risk the risk of a prosecution. So the one doesn't really have to be literally in shackles to assert those rights. The American case, I think it's Miranda versus something, where the emphasis on the risk of a prosecution is asserted. Now, if we put then that to bed, what we then have is a situation where somebody is saying to the chair, bona fide, I am, if I want to put it crudely, I'm refusing to answer your questions, but I'm not refusing because I want to refuse. I'm refusing simply because I want, A, to understand what's happening with these criminal charges, or B, at worst, to go to court to assert my right not to answer those questions. In other words, to assert whether I do have a right to refuse or not. Yes, and we humbly then ask the chair to look at it with those eyes, that it's a Section 34 type of inquiry, because the chair doesn't have to believe that if we go to court, for example, we will succeed. Whether we succeed or not is another question. We are simply asserting the right to go to court and clarify if we are compelled or not compelled. And then, of course, just out of common sense, Chair, it would be futile to say, oh, well, okay, you can go to court, Mr. Mbofu, with your client, but in the meantime, I want to hear him on this and this and that, because then it will defeat the very purpose of asserting those rights, and thereby deny him his Section 34 rights, so to speak. Now, the only point I really want to make, Chair, is the following. The ambiguity arises from the recent amendment to the terms. I'm prepared to say that...
To the regulations.
To the regulations, rather. Okay. Regulation 11 in particular, yes. I'm prepared to say, without committing myself, that before that amendment, this situation would not have arisen. Because at that stage, it was very clear that answers that you give here were completely protected. Now, we know in reality, I'm sure the police watch the commission proceedings as well, but let's put that aside. So in theory, your answers were protected. What has since happened, and for other good policy reasons, is that Regulation 11 was introduced so that the commission may assist other law enforcement agencies. And that it is in that context that the risk that we perceive arises. And it might be that we perceive a risk that's not existent or not, or whatever, but that will be determined by a court of law in due course. But at the very least, the chair just has to be convinced that we, in good faith, we perceive that risk. And due to the perception of that risk, we therefore humbly request that the compulsion to testify be suspended or stayed until such time that we are able to allay the risk. So that's in a nutshell the situation, Chair. If the Chair has any questions, that's the anchor of the application, as I said, of the two applications. The first one being that we suspend until the criminal charges are finalized, or the Chair could say, no, I'm only suspending until you clarify your rights. And we have said in the heads, which is not in the application, we also said that obviously the Chair would have a discretion on saying, for example, you must assert your rights within, I mean, we can't wait for 10 years before you assert your rights. It must be done reasonably, within a reasonable time, or report back to the Commission as to progress. Or even, well, I suppose the Commission would still be cited anyway in those proceedings as an interested party. Thank you, Chair.
Well, the one issue is, of course, that Mr. Mukhetsi has, if I recall correctly, has submitted his version,
Two affidavits.
2 affidavits.
That's correct.
Yeah, already to the commission. Assuming that in doing so, he has fully disclosed to the commission all that he knows that is relevant. That means that his version is already before the commission. Now, that being the case, it doesn't seem to me that he ought to be concerned that he might incriminate himself in any way. He has already disclosed his version. So even assuming that those Section 35 rights were applicable in his situation, there would be, it seems to me, there would be that difficulty. The only thing that, as I see it, he might be saying is, well, when I'm in the, on the witness stand, I'm going to be asked questions.
Yes.
Where I might have to elaborate and so on and so on. But I'm not sure how weighty that would be, particularly before you know what the questions are.
Yes.
You know, it may be that it's a situation where when you have taken this witness stand, you are asked questions, there'll be questions that you feel you can answer, there is no problem. Then there may be questions where you feel that you are not comfortable answering. That may be the situation. It might not be a situation where you refuse to take the witness stand.
Correct.
You see, because it's important to draw the distinction.
Yes.
Refusing to take the witness stand and taking the witness stand, but refusing to answer certain questions because of certain reasons, and being willing to answer other questions. You know, so there is that. I know that. I may be mistaken, but I think there's a witness who came who had a concern like that and said, okay, we'll see as we go, but felt quite free to answer. There was no problem. Yeah. So there is that. And then, of course, as you know, there is the problem that the lifespan of the commission is limited. And we are really trying to finish. Of course, if anybody goes to court, that gets out of our control. We have no control as to how long that takes. We can make submissions and the court would decide, but it could be that we end up not having the benefit of his evidence in circumstances where one would really have preferred to have the benefit of his evidence because of the important position in government he occupied as the accounting officer. So one, there is the problem about the lifespan. Two, there is of the commission. I mean, we are trying to finish the hearing of oral evidence by end of this year, so that the 3 months of our lifespan next year, January to March, is used for the writing of the report. We have a lot of witnesses who must still come. So there is that problem. We have already lost 1 day with regard to him. And now if we postpone the hearing of his evidence, we lose another day. That's 2 days we have lost relating to him alone. So there are those concerns.
Yes,
And of course, once one accepts that the Section 35 rights don't apply, then it seems that the only basis, and you must tell me if I misunderstood your submissions, the only basis on which the postponement application is made is really that he wants to clarify in the court what the position is in the light of the amendments to the regulations. Is my understanding correct?
Chair, let's put it this way. His position is that he should not be compelled.
Yes.
But obviously, that's his position.
Yes, yes.
Someone else might have a different position.
Yes, yes.
And therefore, that dispute.
But what is the ground for that position?
Yes.
The legal ground for it?
Yes, thank you, Chair. Yes, the legal ground, and that's, I wanted to respond to that first. We don't accept, Chair, that the Section 35
rights
do not apply, yes.
Okay.
And that is for the following reason. Firstly, as we said, on the basis of the arrest or non-arrest, he's in, so to speak. But on the basis that the chair raises, which is quite an important consideration, namely that what has he got to lose because he has already made 2 statements. We, with respect, don't. Our submission is that is not something that would exclude Section 35 for the following reason, Chair. In fact, the chair has given half of the answer I was going to give, namely that the risk, remember we're dealing with a risk here, the risk of self-incrimination still exists because obviously the obligation to give evidence goes hand in hand with the duty to answer questions or to be cross-examined for that matter. Yes. And then you are in a different zone altogether, as we know, to a statement that you made than when you are confronted with this, that, and the other. Because that's exactly where the incrimination actually comes, not so much in what you say than what may be extracted. Which goes, again, I'm agreeing with the chair, particularly on the second issue, which is that this is not, we're not asserting a right not to testify as such. And the chair will know that there's a long line of cases about exactly what the chair was saying, that, for example, the way it's put in the cases is that it doesn't prevent you from taking the oath, for argument's sake. So you can't say, no, I'm not taking the oath because of the right to self-incrimination. So literally speaking, that right is asserted question by question by question by question, but we all know that you may just then not just stand there and take the oath and say nothing, so which is the same thing as not testifying as it were. So I'm with the chair there, but where we part ways with respect, Chair, is the fact that the fact that he has made statements, in my respectful submission, does not nullify the entire right. Or it's not so much, it's not like a waiver of the right, because he might have waived part of it by giving the affidavit, but there's still the residual right of against cross-examination, so to speak. That's the first thing. The second thing, Chair, is that actually that even the fact that he has given evidence is actually a point in our favor. Because A, it shows that this is not someone who's trying to be difficult. Where he had a duty to cooperate, he did. But where he has now obtained legal advice, which, by the way, the chair gave him a postponement so that he can get the legal advice. So the chair can now say, well, the legal advice you got, I don't like it.
Well,
I'm not saying the chair is saying that.
I say nothing about legal advices.
Yes, I'm simply saying the legal advice is what it is. He genuinely has received legal advice that says this is a gray area, it might need to be clarified. So this is not somebody who's, trying to dodge the commission. He was here every time, even now when the dates were changed, he made amendments to his schedule to be here. So that's the first issue. The second issue, which is probably more important, Chair, is that and this is about prejudice. The commission is not really prejudiced in the sense that it is left with nothing. The commission has got his two statements, and therefore it would mitigate at best any prejudice that the commission would suffer, because they already have his version. The only thing the commission would be deprived of is the opportunity to confront him with this and that and the other. So it's not so as if the commission will be left with nothing. And apropos, the only point that really I can't, where I have full sympathies with the commission, knowing the history, is the fact that, we all know that there's pressure to finish. But that, in my respectful submission, if we accept the rights, the existence of the rights, we can find each other with the evidence leaders or with the chair, and to make it practical, that this is not a never thing. Either we have to report here within a particular period as to the progress, or if it looks like that case is going to take forever, we may come back and the chair might say, well, I'm changing my ruling or whatever. But I'm just speaking off the cuff.
Yeah.
So, but I'm just saying that the risk of losing him completely is one that probably can be mitigated. But the real issue is whether I'm correct, Chair, in that the Section 35 rights are still applicable or not. Because if they are, then the rest is about finding ways around the problem.
Okay, so just to make sure I understand, so the entire basis of the application is that the Section 35 rights are applicable.
That's correct. That's the anchor.
That's where the argument is anchored.
Yes.
Yeah.
And that the second leg of the anchor is the fact that the latest amendment to the regulations at best create an ambiguity, which might need to be clarified by a court.
Okay. No, that's fine. Let me hear Mr. Pretorius.
Thank you. Thank you.
Thank you, Chair.
Yes, Mr. Pretorius.
We have prepared heads of argument. They should be included in your bundle, Chair, page 37.
Yes, I see that.
Chair, because this is a matter that may create a precedent, or will create a precedent either way, because it may well affect other witnesses who are called to appear before you, we have taken the trouble to prepare comprehensive heads, which are now before you, but I will attempt to summarize them for the purposes of present. Chair, by way of introduction, this commission is set up to investigate criminal activity, state capture, corruption and fraud. It is inevitable, therefore, and contemplated by the President when setting up the commission, by the court when confirming that the commission should proceed, the full bench, and by the scheme of the Act and regulations that people implicated in criminal activity will come to testify. So it's not anything exceptional, it's the rule. And this commission is obliged, it's not a matter of choice, this commission is obliged in terms of its reference, in terms of its terms of reference, to investigate those matters, to call those witnesses, particularly implicated persons, because if it didn't call implicated persons to explain conduct alleged to have been undertaken by them, it would be acting unfairly. So the first point is that it is nothing unusual. In fact, it is the rule that implicated persons come to testify before the Commission. And it's the duty of the Commission to fully ventilate all versions, including those of implicated persons. But the law caters for that situation. And so the application at present is opposed not only in the circumstances of this case, but as a matter of general principle, both the main prayer and the alternative prayer. The first factual point that must be made is that Mr. Mkhesi has not been arrested, nor has he been charged with any offence. First point. Secondly, he is a compellable witness and does not have a right to remain silent. Now, there's a distinction between the right to remain silent on the one hand and the privilege against self-incrimination on the other. There's no right to remain silent. If Mr. Mkhesi had been arrested, he could, in the criminal proceedings, say, I'm not saying anything at all. Whether it incriminates me or not, I have a constitutional right to remain silent. That is inherent in my right to a fair criminal trial, and I'm exercising it. What we're really dealing with here is the privilege against self-incrimination. And the Commissions Act, although it is clearly outdated, and the regulations as amended deal with that. I might just mention at this stage that the section quoted in the application of Mr. Mkhesi is the old unamended section. The section that deals with the right not to answer incriminating questions is in the Act 3.4, and the use immunity, and I'll come to that technical term, direct use immunity, is in the regulations. So there are two protections. The first is the privilege in section 3.4 of the Act, and the regulations deal with the fact that any incriminating answer may not be used in any criminal proceedings against an accused person. So in paragraph 4.5, we deal with section 3.4 of the Commissions Act, and in paragraph 4.4, we deal with regulation 8.2. In paragraph 5 and following, we deal with the point I made initially, Chair, and that is simply that this commission has a mandate to do what it's doing. In this case, it has a mandate to summon or call Mr. Mkhesi to the witness stand and to get his version in relation to allegations made concerning the Free State asbestos project matter. Again, I stress, Chair, it's not a matter of discretion. It's not something that the Commission would like or not like to do. The Commission has to do it in order to be fair, amongst others, to Mr. Mkhesi. So, Chair, the heads deal with that at paragraphs 5 to 10 on pages 2 and 3. In essence, Chair, the applicant, Mr. Mkhesi, has been implicated in evidence relating to the Free State asbestos audit. I'm instructed that he has not been summoned to testify, so that should be corrected, even though Mr. Mkhesi says so in his founding affidavit. But I may be wrong there. I haven't been involved in the matter from the beginning.
Yes, I seem to think it would be unlikely that he was summoned, but
Yes.
yeah, because as I understand it, he has been cooperating.
Yes, Chair. But what he does seek is a postponement of an appearance here, Chair. I've made the point, Chair, and I'm moving to page 4 of the heads, that the right to remain silent is only available to an arrested or accused person in criminal proceedings. What is important about it is that it relates to criminal proceedings. And what is important about it, it's entirely distinguishable from the case, and you referred to the case of Mr. Manye, who came where you ruled that he had to answer questions, but could assert a protection under the regulations in relation to a particular question, not questions in general. So in a criminal trial, an accused can say, I'm not saying anything at all. You don't have to bother whether it's incriminating or not. I have a right to remain silent. It's a constitutional right. It's essential to the fair trial. Certainly, Mr. Mkhesi doesn't have that right. The question is, what other protections does he have given the overall mandate of the Commission? The legislature has decided that implicated persons must appear when summoned to do so, or may appear under a consensual arrangement. But it says, because certain questions put to you may incriminate you, you may either, in terms of 3(4) of the Act, assert a right not to answer, the privilege against answering self-incriminating questions, or in terms of the regulations, Regulation 8.2, if you do answer deliberately or not deliberately a question which involves self-incrimination, that then cannot be used against you. You are protected. And that is the scheme of the law. And if, Chair, you refuse the application, you would be doing no more than applying the law. No question of a misdirection which is subject to review, but I'll come to the review point later. Chair, what the scheme of the legislation that applies here, read with the regulations, seek to achieve is a balance on the one hand between the duty of a commission of inquiry to inquire into, in this case, criminal activity fully and to hear all those involved and implicated in order to fulfill a statutory, in fact, a constitutional mandate on the one hand, and the protection of accused or potentially accused persons on the other. And the manner in which the legislature and the regulations have dealt with that is to provide protection in 3(4) and protection in Regulation 8.2, and I've dealt with that. Of course, as the learned author Jason Beer says in the work on public inquiries, one may remove any privilege. That's one option for a lawmaker, to say you're not going to have any privilege in a commission of inquiry. The other way, and this is a 19.2 of the heads, is to maintain the privilege against self-incrimination, but also, as the regulations do here, to grant some form of immunity against the subsequent use of the evidence. And if I may just place on record the Constitutional Court decision in Ferreira versus Levine. Legislatures, says the Constitutional Court, have sought a legislative solution to the tension between the privilege against self-incrimination and the interests of the state in investigative procedures of various kinds. This has been achieved by compelling examinees to answer questions, even though their answers thereto might tend to incriminate them, and at the same time protecting the interests of those examinees by granting them either an indemnity against prosecution or conferring some form of use immunity in respect of the compelled testimony. That's the position in Ferreira versus Levine. However, in this case, there's the added protection under 3.4 of the Act, which says that you have a privilege and you don't have to answer questions even though they incriminate. So the scheme that governs this commission goes further and grants more protection than that granted in Ferreira and Levine. And Chair 21, we quote the correct and amended version of Regulation 8.2 that was amended at the commencement of the Commission's activities in 2018, you will recall, Chair. It reads, a self-incriminating answer or a statement given by a witness before the Commission shall not be admissible as evidence against that person in any criminal proceedings brought against that person instituted in any court, except in criminal proceedings where the person concerned is charged with an offence in terms of Section 6 of the Commissions Act. That's perjury. So apart from perjury, anything that Mr. Mkhezi says here before you, Chair, even if he answers a self-incriminating question, and that answer incriminates him, may not be used against him in criminal proceedings. It's as if he exercised a right to remain silent, but in respect of that question. But there's a further remedy that Mr. Mkhezi can use, as I've said, and perhaps too often now, Chair, 3.4 of the Act, which says he can refuse to answer the question and rely on that. Now, Chair, there's some debate about what Section 3.4 means, and it's apparent inconsistency with Regulation 8.2. But as I understand the approach that you have taken, Chair, up to now, it's that both apply together. So in summary, Chair, what the position is that if Mr. Mkhezi has asked a question, the answer is self-incriminating, and he answers, he's protected under the regulations. He may also, but in respect of a particular question only, not in respect of evidence as a whole or even a category of evidence, in respect of a particular question, say to you, Chair, I don't want to answer this because I assert my right in terms of Section 3.4 against self-incrimination. So, Chair, the principles then that we submit respectfully will guide you in your decision are contained in the heads up to paragraph 27. The only further point that needs to be made before I deal with the alternative order is the issue of how the right not to answer a self-incriminating question under 3.4 of the Act is exercised. And there's clear authority that a witness cannot attempt to deal with that right or exercise that right on a blanket or category basis. It must be done in relation to a particular question. So in paragraph 33, we submit, privilege cannot be relied upon by a competent and compellable witness to resist appearing as a witness or to refuse to answer at all, that is, to remain silent. Rather, the privilege must be claimed in respect of each question, and we cite the authority, and the judicial officer, that would be yourself, Chair, before allowing the claim of privilege, must satisfy himself that there is, quote, reasonable ground to apprehend danger to the witness from his being compelled to answer, unquote. And further authority is quoted there. This danger must be real and appreciable and not of an imaginary or unsubstantial character. The privilege may thus not be claimed where the possibility of criminal liability has removed, such as where a witness has been indemnified in terms of Section 204 of the Criminal Procedure Act. So we say in paragraph 34 that Mr. Mkhesi may indeed invoke his privilege against self-incrimination to avoid dealing with the accusations put to him, but must do so explicitly in relation to a particular question and by saying that his answer would tend to incriminate him. If I could deal briefly, Chair, with the alternative prayer. Pending any clarification of the law, Chair, the witness, in this case Mr. Mkhesi, retains his rights as I've outlined them, both in terms of the Act and regulations. There is no basis upon which he can rely on a right to remain silent. And your finding that, Chair, is certainly not a reviewable finding, because the right to remain silent is a Section 35 right in criminal proceedings. He clearly doesn't have and can't have a right to remain silent, given the statutory framework within which this commission, which is investigating criminal activity, operates. If, however, you, Chair, and I deal with this on an entirely theoretical basis, were to say to Mr. Mkhesi, no, you must answer that question, even though it is self-incriminating, then there would be a right to take your decision on review, because there would be a clear violation. Yeah. But there's just simply no prospects of review in this case. The reliance on the recent amendment to Regulation 11 is, with respect, in our view, incorrect. Once Mr. Mkhesi has given evidence, and I'm talking about the recent amendment to Regulation 11, which allows disclosure. Once Mr. Mkhesi has given evidence, the evidence is in the public domain. One doesn't need Regulation 11 for the law enforcement agencies to listen to the evidence on the website and to access the documents that are part of it. So if Mr. Mkhesi gives evidence and answers whatever questions he answers, subject to the protections he has, all that the law enforcement agencies then do is they go to evidence in the public domain, which they can then use. But they will not be able to transgress the provisions of Regulation 8.2 and use against Mr. Mkhesi any answer that he gives. They may use it in other cases, but not there. So the reference to the amendment to Regulation 11 really doesn't apply in this case. If he doesn't give evidence, his statement, insofar as aspects of it have been put to other witnesses, and that's also in a public record, may be used. If they are self-incriminating, they may also be used because he didn't give that evidence. So the situation is not affected by a recourse to regular. There's nothing that needs to be clarified. It doesn't pertain to the facts of this case. Those are our submissions, Chair.
Thank you. Mr. Mpofu.
Thank you, Chair. Chair, I agree with most of what Mr. Guterres is saying. And so I'll only really deal with those areas where I disagree with him. Let's start with the last point that he made. It can be, Chair, that Regulation 11 has no impact on at least the perception of the risk that we're talking about here. Mr. Pretorius, with respect, can't have it both ways. Remember that the old Regulation 11 afforded certain protections. It's obvious by a reading of the current Regulation 11 that it removes those protections. There's no doubt about that. So to the extent that those protections are removed and information may now be accessed by the so-called state law enforcement agencies, that must count for something.
Well, maybe we should look at the actual wording.
Yes.
Because it may well be that the fact that they may access certain information does not detract from the fact that that information may not be used against the person who gave evidence at the commission, but maybe that information may be used against somebody else.
No, I accept that, Chair.
Yeah.
But all I'm saying is that just as a general theoretical statement,
Yeah.
surely those protections were there to protect somebody like Mr. Mokgesi from taking the risk in answering questions here, that those questions might be used against him in related criminal proceedings.
Yeah.
That must be so. So the removal, ipso facto, the removal of those protections must expose him to some risk. I'm not even prepared to quantify
Yes, okay.
what that risk is. Secondly, let's take an example, Chair. Let's assume the Chair were to say, okay, look, I want to protect you, and this is just off the cuff. So I'm going to ensure that you give evidence in camera, for argument's sake, so that the law enforcement agencies who might be watching television might not hear what you say. The impact of this regulation is that even that might have protected him before the amendment to the regulation. Now, in any event, he might have that evidence in camera, but the commission still has to share that information. So it would be cold comfort, the fact that they don't get it on television, but they get it a week later. So it's a very impactful development. And as we say, we all know why that was done, because it is to try and accelerate broadly accountability and so on. But as it affects a particular person, we have to be sensitive to the risks that, maybe unintended risks, that it then...
Tell me the clarification that he would be seeking to obtain from the court would relate to what
Yes.
exactly, if one were to accept, as I think both you and Mr. Procedural seem to accept, that once he takes the witness stand, if he is asked a question whose answer he think would incriminate him, he will have a right in terms of the Commissions Act, Section 3, Subsection 4, to refuse to answer the specific question. But otherwise, questions that don't incriminate him, then he can answer. So if one works on the basis that that is what would happen, what is the clarification that he would be seeking in court? What would it be directed at clarifying?
Chair, again, I agree with Mr. Pretorius' analysis of that issue to the following extent, that the if the chair were to say, after he has taken the oath, and then he says, no, I will not answer that particular question, and then the chair says, no, you have to, then the chairs would be then exercising a discretion, as it were, which would be reviewable by a court of law. Yes.
Yeah.
So I accept. Let me take one step back, if I may, Chair. We accept that, and I said this when I was addressing the Chair-in-Chief. We accept that theoretically the right attaches to questions.
Specific questions.
Yes. That we accept.
Yes. Yeah.
We accept that the right to remain silent is not the right that we are asserting directly. We are simply saying that right is a cousin, as it were, of the right against self-incrimination. So is the right to get legal representation and so on. That's a cluster of rights under 35(9), which are related. However, Chair, we appeal to practicality and realism in the following way. The only issue that this commission has an interest in relation to Mr. Mokhesi is specified at Annexure M6 to our application. So I'm sorry, it's not paginated. I'm sorry, let's start at Annexure M3.2.
M3.2.
Yes, that's a letter from Mr. Paper, my instructing attorney.
Yes.
Where it says that, paragraph 2, the Judicial Commission of Inquiry require our client to present evidence pertaining to the asbestos audit conducted in the Free State, being the very same issue investigated by yourself. So that's the crux. There's one issue. He's been told that the police are interested in the asbestos audit issue.
Yeah.
He's been told that the commission is similarly interested in the same issue. So there can be no doubt about the coincidence of the issue. So the commission, literally, he might be asked to come here and say, what is your name? He answers his name. How many children do you have? He answers that, and so on. And then we'll say, okay, now let's come to the real issue why you're here, which is the asbestos audit. Then he says, I'm not going to answer anything. But what's the point of that? I mean, at a practical level, we must accept that this is a single issue on both sides. The police are interested in exactly the same issue that the commission is interested in. So if he has a right not to deal with the asbestos audit issue, I'm putting it at its broadest, then that is the right that he would be asserting. And if the chair found that, no, he does not have such a right, that would be the issue that would be taken to court, as it were. And the court might say the chair is right, or Mr. Pretorius is right, or we are right, that he should be insulated from the risk, the very risk of even dealing with that issue at any level, so to speak, because as I said earlier, this is not a case where, I mean, we can go through that exercise, but it would be a waste of the commission's time, because he'll simply...
Well, I think what you are saying now does seem to me to differ from how I understood you, what I understood you to be saying earlier. It seems to me that if he says, I don't want to answer any questions relating to the asbestos project, that's not an exercise of the right in relation to question by question. He is simply saying, on the topic of the asbestos project, I don't want to answer any question at all, which it seems may include questions that don't incriminate him, you know. So that That's how I understand your argument
yes.
to be now.
No, Chair, I understand the distinction. Remember, now I'm responding to Mr. Pretorius' assertion. So all I'm saying, Chair, that's why I was saying I'm appealing more to practicality than legal technicality. Because technically, we all agree. He can be brought into the chair, he can take the oath, he can tell us all about his life and all that. But when it comes to the real issue why he is here, which is the asbestos audit. Remember, Chair, unfortunately in this case, it might well be that if he actually had already been charged, he would be in a better position, or the chair would be in a better position to say, yeah, but you have only been charged with money laundering, for argument's sake, but not this or that or that. But here, he is in a situation where the risk to him is still ill-defined, so to speak, in the sense that he might answer a question which, as the chair says, might look innocuous at face value, about whether you attended this meeting or that meeting, which at face value is not self-incriminating. But depending on the nature of the actual risk and the charges, that might turn out to be to have been a self-incriminating answer. So it's not your typical situation where the chair could say, no, but these two charges have been withdrawn, so therefore you can answer this, but this one remains, we understand. It's unfortunately a fuzzy situation. The other point, Chair, which I wanted to make about Mr. Pretorius' address is that, yes, no, I've made the point about the Regulation 11 removal of the amendment allows for, the fact that the amendment allows for the disclosure of the information is the new, what Mr. Pretorius is saying would have applied before that amendment. Our submission, respectfully, is that the introduction of the amendment is the one that brings some ambiguity and something for a court to clarify. Chair, as I say, we approach this practically. If the chair says, well, let's go through the motions, he must just take the stand and say his name and so on, well, so be it. But I can tell the chair now that he's not going to answer any questions to do with what he's really been brought here for, namely the asbestos audit. So it would be a futile exercise indeed to compel him to do so. The case that Mr. Pretorius referred to, which is the case of Connison, about that the danger must be real and appreciable and not an imaginary and unsubstantiated in character, is correct. But I addressed that when I was addressing you in Chief Chair, namely that although he is not charged, the threat to his Section 35 rights is real in these circumstances. Just for completion, in the same vein, Corbett CJ in the case of Mahmoud versus Janse van Rensburg, 1993 in the old 1991 SACR 67 in the old AD, called this, it's a personal right to refuse to disclose admissible evidence. In other words, one accepts that the evidence is relevant and admissible in the normal law of evidence sense, but you have a right to refuse to give it for the reasons that we've already explained. And it is in that context that the right that we assert must be understood, and the right that we seek to be clarified, if given an opportunity, must be understood. So just check if I'm leaving anything out, Chair. the Commissions Act, again, before the amendment, theoretically protects one against any criminal consequences apart from lying under oath. That we accept, but again, we put that into the pre-regulation, new regulation level position. That's good. Thank you.
Okay. It may well be, Mr. Wofu, that whether it might prove to be a futile exercise or not, it may well be that Mr. Mukherjee might have to take the witness stand, be asked questions, and if he refuses and asserts his privilege, he does so. If he seeks to assert his privilege in relation to the entire topic of asbestos project, let us know that that is the position he took the witness stand, and that's what he did, so we know what the facts are.
Yes.
He may well, I don't know, but you are his advisor. You have indicated it may well be that he might say, look, yes, there are questions that I can answer, but there are questions that I will refuse to answer, and let's see how it goes. If he says, I refuse to answer any question, then let's have that as an established fact that he took the witness stand. This is what he said, so that if he goes to court, that fact is established.
Basis, no.
That fact is established, you know, to say,
yes.
Is he entitled to refuse to answer any question on a certain topic, or is he only entitled to refuse to answer specific questions on the topic?
Yes.
Yeah.
No, Chair, firstly,
Yes.
I have no problem whatsoever with that.
Yes.
It actually, it will, if there are going to be court
To
proceedings.
clarify things.
Yes, if there are going to be court proceedings, it actually makes it easier.
Yeah.
Because then we won't have this debate about does he have a right to take the oath and so on. Because that will have been done. Yeah.
Yes.
Secondly, Chair, let me maybe make I'll make an appeal to the Chair.
Yeah.
To when he does take the stand, to maybe in a way assist in clarifying exactly that point with him. Are you prepared to go this far and this far beforehand? Because we don't want the risk to materialize inadvertently, so to speak.
Yeah.
But the last submission I want to make, Chair, is that my submission is simply this, that on these facts, the distinction between question to question and the topic is artificial. That's because there's really one topic and one issue, and it is this. It's not as if he's going to be asked about how the state of housing in the Free State and so on.
Yeah.
But I have no quarrel with the Chair's approach of as it were, narrowing the issue and knowing where his preparedness to answer starts and where it ends. We have no issue.
Okay, all right. No.
Subject to, if that's the route that we're going to go, Chair, we'll just ask for 5 minutes so that we can consult with him.
Okay, all right.
Chair, if I may, it will assist, I'm sure, if we just clarify what this Regulation 11, which seems to be at stake in this application, is all about. The regulation must be read with the Act. The regulation in essence, and we're dealing with 11.2 and 11.3, says that the work of the Commission, particularly its investigative work and matters submitted to the Commission, are covered by those regulations and may not be released to any party. Right. Now that goes both to the investigative work of the Commission and submissions made to the Commission. So those are under wraps, as it were, under 11.2 and under 11.3. What the regulation says is that doesn't apply to law enforcement agencies. So the real issue here is that these files behind me can go if the protocol is obeyed, and it's got nothing to do with his giving evidence. The Section 4 of the Act says, however, that sittings must be in public. So once the evidence is given, right, and this is not related to Regulation 11.3 or the amendment to Regulations 11.2 and 3, once that's in the public domain, that is there for anybody to use, even against the witness concerned, but for Regulation 11.2, it can't be used in any criminal proceedings against the witness. So really, the amendment to Regulation 11 is clear in its import, and it doesn't impact upon what the witness does or says. There would have to be another ground, and there is no other ground. And if I may, in fairness to Mr. Mkhesi, just emphasize that the extent of the privilege, according to the international authorities at least, is wide. It covers evidence directly incriminating against the person who gives it, evidence which might be used to inform the case, indirectly incriminating against the person who gives it, and evidence which might be used for the purposes of deciding whether to bring proceedings against the person who gives it. So, widely interpreted, there is an enormous amount of protection afforded to a witness under the rubric of self-incriminating privilege.
I don't think you want to say anything further, Mr. Mpofu, or do you?
Chair, I'm sorry, just,
Yeah.
I suppose I must exercise my right to respond. Again, we're not far apart with Mr. Pretorius. The right in South Africa, at least, and his right that it's widely defined in other jurisdictions. But here it's anchored in Section 203, which simply says, no witness in criminal proceedings shall, except as provided by this Act or any other law, be compelled to answer any question which he would not otherwise have been answered on the 30th of May 1961, that's not important, have been compelled to answer by reason that the answer may expose him to a criminal charge. So it's a double, it's watered down twice. May simply expose him, it might not even materialize. And that's why I summarized it by saying it's the risk, it's simply the risk that is at stake. And that risk on these facts manifests itself, as we say, by the added risk. It might not be a big addition, but by the added risk caused by the amendment to the regulation. That's the only relevance of the Regulation 11 point. Thank you.
Thank you, Mr. Mpofu. The application for the postponement of the hearing of Mr. Mokgetsi's evidence today is dismissed. Reasons can be given in due course if they are requested. Mr. Mokgetsi will need to take the witness stand, but he will be able to exercise his right with regard to specific questions and not to incriminate himself, his right to refuse to answer certain questions. Okay, thank you.
Chair, may we take the short adjournment now?
Yes, we are 5 minutes past the tea break. We're at 20 past. I'll give a little bit more time. We'll resume at 22.
Thank you, Chair.
Okay, we adjourn. Mr. Pretorius will put certain questions to you. Questions which may incriminate you, you may refuse to answer, but Mr. Pretorius will ask you questions, and I would think that there are questions that would not incriminate you, and I would think that there would be questions which, as accounting officer, you would feel that you need to answer and tell the nation that part, and only in regard to the questions which you think incriminate you would you exercise that right. But you have been given advice that you have been given. Mr. Pretorius will ask questions and we'll take it from there. Okay? You understand?
Okay. Should I talk about the advice that I've been given, or not yet?
Well, I don't necessarily. Yeah, your counsel is shaking his head. So I think you listen to questions and yeah. Okay, Mr. Pretorius.
Mr. Mokesi, you have in front of you a bundle, which is FS1. Would you go, please, to page 28? And when we refer to page numbers, we're referring to the black numbers in the top left-hand corner of each page, not the red numbers. You can ignore the red numbers in the top right-hand corner, but we're looking at the numbers at the top left of each page. If you could go to FS1, page 28, please. Do you recognize that document?
Yes, I do. Page 20, FS1, 28.
And
Yes.
the bundle is called FS1. That is the whole file. It's called bundle FS1. But you have been referred to a specific page. Yes. And what is the page, Mr. Pretorius, again?
Page 28.
Page 28.
And if you would just have regard to the document from page 28 to page 54 of FS1, please. You recognize that document?
Yes, yes, I do.
If you go to page 54, please. Is that your signature there above the name N. Mokesi?
Remember to look at the black numbers on the top left all the time.
Yes.
Yes. Is this an affidavit then attested to by you on the 31st of January 2020?
That's my affidavit, yes.
Yes, you would have to speak up, please.
Yes, that's my affidavit.
And as far as you're concerned, are the contents of this affidavit true and correct?
Yes, that's my affidavit.
You'd look at another document, please, at FS 58 to FS 60. There's certain annexures to that document, so perhaps you should go right through to FS 91.
FS 58, you said?
Yes.
Yes.
I'm sorry, Mr. Mokhetsi, for purposes of identifying page numbers, you can ignore FS and Free State. When you look at that, those black numbers on the top left corner of each page, you just look at the last 2 or 3 digits. So when Mr. Pretorius says page 58, he is talking about that page. It says Free State 01-058. That's page 58, but we won't be saying FS what, because the whole file is FS1, so we don't want there to be confusion. Okay, so, but he has asked you to look at page 58 and go up to page, Mr. Pretorius?
Well, including annexures to page 91.
Page 91.
Yes,
Yes.
please. It'll be just before that blue tab. No, just
92.
before the blue tab.
It's page 92.
Yes, so we're going to page 91. There you.
The black numbers, top left.
You have that page.
91.
Yes.
Okay.
And if you could look at the signature, please, on page 60.
Page 60.
60.
Yes.
Whose signature is that? On that page, in the middle of the page?
Yes, that's my signature.
Your signature. This document at page 58 to page 60, is that your second affidavit?
Yes.
As far as you're concerned, are you satisfied that the contents of that affidavit are true and correct?
Yes.
Chair, may those two documents be admitted as exhibits TT 2.1 and TT 2.2.
One is the one starting at page 28, huh?
Yes, Chair, and together with annexures, well, it goes through to page 55. Has no
Yes, the
annexures.
affidavit of Mr. Timotse Mukhetsi appearing at page 28, together with its annexures, will be admitted and will be marked as exhibit. What is the exhibit number?
TT 2.1.
TT 2.1. Okay. The
Second one at page 58.
The affidavit of Mr. Timotse Mukhetsi appearing at page 58 will be admitted and will be marked as exhibit GT
2.2.
2.2, together with its annexures.
Thank you, Chair.
Yes.
We understand from your affidavit, Mr. Mukhetsi, that you were appointed as the head of department, the Free State Department of Human Settlements, with effect from 1 January 2012.
Correct.
When did you actually occupy that position? I see that your appointment was with effect from. Did you actually take office on 1st January 2012 or on another date?
Yeah. My appointment was with effect from the 1st of January, but I assumed office, I think, 2 weeks later.
Thank you.
Okay, I'm going to ask you to raise your voice, Mr. Mukhetsi.
Sorry, I'm saying my appointment letter was with effect from the 1st of January, but the actual taking of office was 2 weeks later.
2 weeks later?
Yeah.
Okay.
Assumption of the report.
Yes, thank you, Mr. Mukhetsi.
You can
Mr.
keep
Mukhetsi,
the mic on, your mic on. You can keep it on with the red light, yeah.
Mr. Mukhetsi, a matter that will be of some interest to the Chair generally, and in relation to the particular circumstances of the Free State project on asbestos, is the role of the head of department. The head of department is also, in terms of the Public Finance Management Act, the accounting officer, I understand. Is that correct?
Yes.
When you occupied the position as head of department and accounting officer, the Free State Department of Human Settlements, did you undergo any training for that position?
I don't understand when you say training.
Well,
It's about, I think it's about going to an interview and
yes.
presenting yourself.
Well, what we're going to deal with in the first part of your evidence today is the various financial controls that exist within a particular government department and the prescripts of the regulatory framework that applies in terms of regulations, practice notes, and I'm talking about Treasury regulations, Treasury practice notes, the Public Finance Management Act and the like. In regard to that network or collection of regulatory prescripts dealing with the finances of the department, did you receive any training?
Well, I don't know about the issue of formal training, but it's as a matter of course in your work you come across those particular legislative.
Well, may I ask then, when you took office, did you acquaint yourself with the various regulatory prescripts governing the finances?
Yes, I did.
And can you recall what in particular you would have had regard to?
Well, the legislative framework being the main one being the PFMA, of course, which is the key legislative framework that governs.
Mr. McKenzie, I'm sorry to interrupt you. Would you remove your mask, please? Apparently, the stenographers are having difficulty hearing what you're saying. Please also speak close to the mic and loudly, if you would.
Okay. No, I'm saying the key legislative framework that you have to acquaint yourself, and that also include all government employees, not only myself, is your PFMA.
That's the Public Finance Management Act.
Public Finance Management Act and its accompanying regulations and so on. So that's basically the key legislative framework that you have to acquaint yourself with.
So that's the Public Finance Management Act, and that would be the Treasury regulations published under the auspices of that Act.
Yes.
But we will deal with those in a moment. But may I ask, did you, at the time of your appointment, become aware of a supply chain management policy applicable within the department? Was there such a supply chain management policy in the department?
Okay. Chairperson, I have been advised by my counsel, because I can see now in terms of where we are going, that I should not take questions that relates to the asbestos matter. And that's the advice that I got.
To supply chain management policy.
No. I'm just highlighting that particular issue to say I've been advised by my counsel.
Yes.
And I take legal advice.
Yeah, no,
as I should.
Understand that, yeah.
But I should not, because in certain instances I will need from, particularly where I'm not certain, I will have from time to time to consult with them. So that's basically the advice that I've taken, just to indicate that particular issue for the record.
Mr. Procedural, do you want to say something before?
Well, except to say the obvious, that it's difficult to understand how an answer to that question can be incriminating. But on the wide definition, it it is in our submission. I'm trying to think how it could be self-incriminating, in fairness to the witness. But I doubt that the mere existence
is
or
about-
otherwise of a policy can be incriminating as opposed to irregular.
The question is directed at establishing whether, when he assumed office as the HOD, there was in place a supply chain management policy.
Okay.
That's all the question is directed
That's all the
at.
question is aimed at
Do- do-
establishing for the moment.
For now, do you have a problem, a concern
No,
about
I
that?
don't, I'm just.
At this stage, you are not concerned. But you are
yes.
saying as we go on, you may have to.
Yes.
Yeah, okay, no, we understand that.
I think
As
my
we go
counsel
on-
will also indicate as well.
Yeah, your counsel is here as well, yeah. Okay, so I don't think there is any discomfort about you answering the question whether when you assumed office as HOD, there was in the department, as a matter of fact, a supply chain management policy.
Okay.
Do you want to answer that?
Do you say there was one?
There was one.
You see, the one that the investigators have obtained is dated May 2015. You assumed office in 2012. So that would have been a different supply chain management policy or more or less the same?
There is a requirement that you should, on an ongoing basis, review your supply chain policy. Because, from time to time, you have this practice notes that changes, and et cetera, and some of the regulation. So it is a requirement. It's actually a good thing to review at least on an annual basis, even if you do not change the policy. But the fact that you reviewed it, and just to make sure that it is still applicable and or still relevant. So the 2015, there would have been previous policies before.
Right, and it would have been amended, you say, to some degree in 2015 to produce the one that we have, that we will deal with later. Yeah. But you say, all I wanted to establish at the moment, that at the time you took office, there would have been a policy in place in the department, a supply chain management policy. Yes, yes, thank you. If I could just go to your affidavit, please, at FS1, well, at page 28. And if we could go through, please, to page 30. There you talk about a written proposal being delivered to your office by a Mr. Mpambani. Perhaps we should identify that policy, and that's in another bundle, which you have seen. It's bundle FS8.
Page?
At page 162, which is a file behind you, if you would go to bundle FS8.
Sorry, you refer to page 30?
Oh, yes,
Yes, I refer to page 31.
31.
In paragraph 9.1, you say, the written proposal was delivered to my office of Mr. Mpambani. I would just like to identify the proposal that we're talking about.
I'm sorry, Mr. Pretorius. Did you say page 31?
Yes, Chair. Of FS1.
Yes.
At paragraph 9.1, the affidavit reads, the written proposal was delivered to my office by Mr.
Oh, no,
Mpambani.
I think
But before dealing with that fact, I need to identify the proposal.
I heard you to say what Mr. Mkhetsi says here is that no proposal was delivered. And I was wondering because I couldn't see anything saying that. But maybe I misheard
That's
you.
entirely my fault,
Yeah,
Chair,
okay.
not speaking clearly enough.
Okay.
The proposal was delivered, and we have substantial evidence in that regard already before the Chair. But if you would go to FS8, please, at page 162. you recognize this document, Mr. McKessie?
Yes, I do.
What is it?
The proposal?
This is the proposal for the audit handling of hazardous material removal and disposal of asbestos roof houses, submitted to the Department of Human Settlements, Free State Province. Attention, Mr. McKessie, and it's dated 28 May 2014. Do you see that?
Yes.
And it's submitted by, and underneath that, submitted by, you see, Blackhead Consulting and Diamond Hill Trading 71.
Yes, I see.
Now, that proposal has been dealt with in evidence before the chair by other witnesses, and we will return to it in due course. But for the present, I understand your affidavit to be to the effect that that proposal was delivered to your office by Mr. Mpambane. But you continue to say, however, at the time of such delivery, I did not personally meet Mr. Mpambane.
Mm-hmm. Yes.
Is that statement correct?
Yes, correct.
When did you find out that Mr. Mpambane had delivered such a proposal? Can you recall?
No, I can't recall exactly the date when it.
Did you make any inquiries from any person or entity as to who Mr. Mpambane was and who he represented?
No, I didn't.
You didn't, right? You do say in paragraph 9.2 that before the proposal was delivered to the department, specifically my office, I did not know or expect that either Mr. Mpambane or Mr. Sodi would deliver such a proposal. I cannot even recall the date on which it was delivered. Is that a correct statement of fact?
That I did not know them before. Yes, I did not know them before.
You did not know them. You can feel free to remove your mask if you're comfortable with that, Mr. McKessie. And as I understand the situation, both from your statements generally and from other evidence that has been given to the chair, the department did not ask for a proposal. It did not, the technical word is solicit the proposal.
No.
It did not.
Yeah.
Right. Again, please, if you would raise your voice.
I'll ask you to raise your voice, Mr. Mkhwezi.
No. Yes.
Yeah, the department did not ask for proposals.
Yes.
Yeah.
I also understand from your affidavit that when you received the proposal, right, you then forwarded it to Mr. Matlakala.
Yes, I did.
Right. You say that in paragraph 11.1 of your affidavit that we're now dealing with at page 32. If you would just go there, please. In paragraph 11.2, you say, by referring the proposal to him, I was expecting him to make a determination on the appropriate method of procurement that could be utilized to implement the project.
Yes.
You see that?
Yes, I see that.
Now, when you received the proposal, did you study it?
Yes, I went through it and obviously refer it to the supply chain director.
All right. And this would have been in May 2014.
Possibly around, yes, I think it will have been around that time.
On that date or around that date?
Around that, yes.
Did you understand that if the proposal had not been solicited by the department, certain regulatory prescripts applied?
Please switch on. Yeah.
Yes, and that's the reason ordinarily you refer that to the practitioner. In this instance, the supply chain practitioner.
Well, we'll come back to that issue in due course, but if I may ask you to go to another file, that's FS6, page 371. That is a file that will be behind you, but someone will help you with that.
I think somebody will assist you to get the file.
Three, 371. This document is the transcript of the interview that you held, Mr. Mkhesi, with the investigators of the Commission on the 30th of October 2019. You've been provided with this document.
Yes.
Your voice is very soft.
Yes.
Yeah, okay.
At page 371, you will see a discussion between Mr. Lamprecht, the investigator, and yourself from line 10. The lines are marked on the left-hand side of the document.
Yeah,
Mr. Lamprecht says, okay, so when you received the proposal, what did you do then? You see that?
Yeah, but it's not Mr. Lamprecht here, it's the 371 is Mr. Swanepoel.
Are you at page?
I'm sorry.
371. Oh, 37, okay, no, sorry.
Oh, you
on
looked
the
at the
black
right numbers.
Black numbers.
Oh, yeah, look for the black numbers.
Okay.
Right. There, Mr. Lamprecht is recorded as having said, okay, so when you received the proposal, what did you do then? And your answer was, I refer that to the supply chain.
Yes.
And then at line 20, Mr. Swanepoel asks, so what does that referral mean when you refer something to him? And the answer is, if I refer something to him, it's one look at it, in other words, the implementation thereof. What process should we follow? Should we go out to tender, or should we go out or tender? What is it? Do we have to follow any specific regulations or whatever? And obviously, they are the procurement specialists. They have to advise in terms of what we should do. I'm now over the page at page 372. See that? Is that a correct factual statement?
Yes.
Then Mr. Swanepoel asks, so in other words, and you can correct me if I'm wrong, I understand that you're saying that when you refer something to the head of department, the head of procurement, Mr. Matlakala, that he would assume the department wants to go ahead with the project, he must now start finding out how to proceed. Your answer is how to proceed. Mr. Swanepoel says, am I correct when I say that? Mr. Tim Mukesi says, yeah. Is that correct? Is that a correct statement of fact?
Yeah, I think what was, yes, okay, because that was the discussions.
The exchange between yourself and Mr. Swanepoel continues at line 11, where Mr. Swanepoel says, so by when you refer something to him, you indicate the department decided to go forward with this proposal. Mr. Mukesi says, yes, how should we implement that? Mr. Swanepoel says, Mr. Tim Mukesi, or how should we proceed? Okay, maybe to use the correct word, how should we proceed? You see that?
Yes, I see that.
It appears from this exchange, and it's consistent with your affidavit, Mr. Mukesi, that at a departmental level at least, you made an in-principle decision to proceed with the project, subject to Mr. Matlakala dealing with supply chain management issues.
Yes.
I'm not sure what we can do, Mr. Mukhetsi, with your soft voice. It's very soft.
I'll try my...
Yeah, and maybe look this side when you answer. Maybe it will help me to hear and what you are saying. Okay.
My apologies.
Okay, all right.
Let's just go back, please, Mr. Mukesi, to the legal framework within which procurement exists in a government department, and particularly within your department in relation to the procurement that occurred in this case. You are no doubt aware of the general provisions of the Constitution at section 2171, that when an organ of state in the national, provincial or local sphere of government or any other institution identified in national legislation contracts for goods or services, it must do so in accordance with a system which is fair, equitable, transparent, competitive, and cost-effective.
Yes, that's what the law says.
And the requirements which must be complied with in procurement, it is clear, are interrelated. It must be fair, it must be equitable, it must be transparent, it must be competitive, and it must be cost-effective. I presume you would have no difficulty with the proposition that one of the ways that cost-effectiveness is achieved is through competitive bidding.
Yes.
Let's then go to the Public Finance Management Act, if we may. Section 38 deals with the general responsibilities of accounting officers. Now, I understand that you agree that as a head of department, you would have been an accounting officer in terms of Section 38 of the Public Finance Management Act, correct?
Yes.
And you would have acquainted yourself with the provisions of the Act applicable to accounting officers on assumption of office, or even before then. Am I correct?
Okay. Yes.
Section 38(1) reads, the accounting officer for a department, trading entity, or constitutional institution A, must ensure that that department, trading entity, or constitutional institution has and maintains effective, efficient, and transparent systems of financial risk management and internal control. And there follow various others, other provisions which constitute obligations on the accounting officer. What must be in place in your department?
Yes.
It also says in 38(1)(b), the accounting officer is responsible for the effective, efficient, economical, and transparent use of the resources of the department, trading entity, or constitutional institution. In other words, resources there would include financial resources. Correct?
Correct. Okay.
I'm not going to take you through all of those, but in summary, there are a number of provisions there which place obligations on the accounting officer of a department, in this case yourself as head of department of the Free State Department of Human Settlements. Am I correct?
Correct.
We can deal with them in due course if the need therefore arises. But if I may just refer you to section 38(2), of which you may well be aware, it says an accounting officer may not commit a department to any liability for which money has not been appropriated. In short, you can't spend money which is not budgeted for. Is that correct? Yes. Again, you would have to say yes for the stenographer's sake and the chair's sake.
Yes.
Section 50 of the Public Finance Management Act deals with the fiduciary duties of accounting authorities and, amongst other things, speaks to the exercise of the duty of utmost care to ensure reasonable protection of the assets and records of the public entity. Correct. There's a high degree of responsibility placed on an accounting officer. In other words, the legislation says not just care, it says utmost care. You're aware of that?
Yes.
Then, if I may refer you briefly to section 51 of the PFMA, and I'm really summarizing as we go through. We don't want to go through every word. You are aware of these provisions, and we may deal with them in more detail later. But section 51 deals with the general responsibilities of accounting authorities. And 51(1)(a) says an accounting authority for a public entity must ensure that that public entity has and maintains an efficient, I correct myself, an effective, efficient, and transparent systems of financial and risk management and internal control. Is that correct?
Yes.
You recall that
Yes.
provision. And then 51(1)(a) Roman 3 says that the accounting authority must ensure that the public entity has and maintains an appropriate procurement and provisioning system which is fair, equitable, transparent, competitive, and cost-effective. In other words, a system which complies with the constitutional provision of Section 217.
Yes.
It repeats Section 217. There are various other duties, such as the duty to avoid irregular expenditure, fruitless and wasteful expenditure, and other matters. Correct? Yes.
Yes.
Sorry, I didn't mean to put words in your mouth. I was just repeating what you said. Section 44 deals with the duties of accounting officers and the extent to which an accounting officer may delegate. Right? Now, you've said that As I understand it, that you did not study the proposal, but you sent it to the person in charge of procurement, and that was Mr. Matlakala, as I understand it. Is that correct? For his consideration.
I said I read the proposal and
You read it?
Yes, I read the proposal and then referred it to the supply chain practitioner.
Then let's clarify that. Did you, as I understood it, your evidence was that you didn't study the proposal in terms of the various legal prescripts that would have applied to an unsolicited proposal?
Not in terms of the prescripts that are applicable, but to say what is the most appropriate
Yes. All right,
procurement strategy for.
I'm sorry I interrupted you. Did you finish?
Thank you.
I might have blocked out your answer. You want to repeat that?
I've clarified that.
You've clarified that. All right, section 44.
Okay. I just want to make sure. The clarification you were making, Mr. Mukhetsi, is that after receiving the proposal, you did read it to understand what it was
Yes.
about, and then you
yes.
referred it to Mr. Matlakala.
And the relevancy of it to us,
Yeah.
and then refer it to the supply chain practitioner to say what is the most appropriate
Yes, way forward.
way forward in
Okay.
terms of procurement strategy that we
Okay.
can use.
Right, section 44 of the PFMA says, or deals with rather, the assignment of powers and duties by accounting officers. And it reads in subsection 1, the accounting officer for a department, trading entity, or constitutional institution may, A, in writing, delegate any of the powers entrusted or delegated to the accounting officer, that's yourself, in terms of this act, to an official in that department, trading entity, or constitutional institution. You're aware of that provision?
Yes.
It goes on to say in subsection B, or instruct any official in that department, trading entity, or constitutional institution to perform any of the duties assigned to the accounting officer in terms of this act. You understood that, no doubt, to be the case.
Yes.
Was there any written delegation to Mr. Matlakala in relation to any of the duties that would have rested on yourself?
There are delegations for each of
And
the
would there
staff.
would there have been written delegations?
There will be written delegations
And those would be available to the investigators should they require them?
should they require them.
Right. Section 44 goes on to say in section 44(2), a delegation or instruction to an official in terms of subsection 1, and then there are various subsections again, and I'm going to subsection 2(1)(d), does not divest the accounting officer of the responsibility concerning the exercise of the delegated power or the performance of the assigned duty. As I understand the position is that you may delegate, but you remain accountable.
Correct?
Is that correct? Again, please, sorry to nag you, Mr. McKessie, but the stenographer needs to pick up
correct.
your voice. Thank you.
Okay.
Let's then deal with your own policy. That is in FS7. If you would go there to that file, please.
Somebody will assist you to identify the correct file.
You would go, please, to page 107 of FS7, and we're again referring to the black numbers in the top left-hand corner. Do you recognize the document at page 107?
Yes.
What is that document?
The supply chain policy.
Is that the internal departmental financial management policy,
Yes.
supply chain management policy of which we spoke earlier?
Yes.
It's dated the 6th of May 2015. Is that your signature there?
Yes.
Now, of course, we are dealing with matters that took place in 2014. So if this policy, to your recollection, differed in any respect or to any extent with any earlier policy or the policy in place in 2014, you will please tell the chair that.
Okay.
We may go to FS7 at page 110. You see under the heading Objective, paragraph 1, paragraph 1.1 says, since the department uses public funds to finance its procurement of goods and services.
Sorry, Mr. Pretorius, you said 110.
110, yes. Top left-hand numbers in black.
Okay. Yes.
Under the heading Objective, paragraph 1.1 reads, since the department uses public funds to finance its procurement of goods and services, it is obliged to ensure that the best interest of the public is served when these funds are spent. Best interest, in inverted commas, includes satisfying the requirements at the most favorable conditions, including fairness, equitability, transparency, competitiveness, and cost-effectiveness. Business and industry should be afforded the best possible opportunity to satisfy such requirements while adhering to the national government's medium-term policy initiatives, including broad-based black empowerment, BBBEE, and the Preferential Procurement Policy Framework Act. 1.2 reads, the objectives of this policy are to, Roman 1, ensure compliance with all applicable legislation and prescripts relating to supply chain management. Roman 2, ensure consistency and uniformity in supply chain management practices. I've read that correctly, have I?
Yes. Yes.
And this would have been the objective of any prior policy.
Yes, correct.
And what is apparent is that right from the Constitution through to national legislation, Treasury regulations, which we will come to in a moment, and the policy that exists within the department itself that we are now referring to, there are strict controls which govern procurement and expenditure of government departments. That's a fair summary of the position.
Yes.
At page 112, we have a definition of fruitless and wasteful expenditure. Briefly, what is fruitful and wasteful expenditure?
Fruitless, Mr. Pretorius.
Expenditure
He said
in vain.
fruitful.
Apologize, it's
He said
close to
fruitful, Mr.
long
Mufezi.
German, Chair.
He meant
Fruitless
fruitless.
and wasteful
It's-
expenditure.
It's expenditure in vain, in short. Expenditure in vain.
Right. And the definition continues to be expenditure that could have been avoided had reasonable care been exercised. Am I correct?
Yes.
And it's not necessarily unlawful expenditure. Am I also correct in that?
Well, if it's expenditure in vain, it must be unlawful.
Well, let me put it another way, Chair. It's to be distinguished from irregular expenditure. Fruitless and wasteful expenditure is something different from irregular expenditure. Do I understand the position correctly?
It's what?
Well, one has the concept of fruitless and wasteful expenditure. That is expenditure made in vain,
Yes,
that could have been avoided had reasonable care been exercised.
correct. Okay.
And then there is irregular expenditure. The definition is at the bottom of the same page. What is irregular expenditure?
Yes.
Do you know
Oh,
what?
you're asking me a question.
Yes, I am.
Okay. It's either a expenditure that is, I can just give you an example to say this is an expenditure that is against the policy framework. That could be,
Face this side, Mr.
Okay.
President, yes.
expenditure, I'm just making a few examples,
Yeah.
just one or two examples. Against policy, you violated your own policy, for example. That could also be part of irregular expenditure. Or you did not
Follow processes.
follow, yes, that's one of the issues. Or when it is put on the landscape, those fair, transparent and so on, one of those issues are missing, then that will then qualify as an irregular expenditure, not necessarily wasteful.
So irregular expenditure may be expenditure which was made or incurred or made for a valid reason, for a valid and acceptable objective. But the manner in which it was made makes it irregular. Yeah, and it would include, would it not, unauthorized expenditure. In other words, if before you spend that money, you are supposed to get authorization from the HOD, and you don't get that authorization, that would still be irregular, would it not?
Yeah, it doesn't necessarily mean that all unauthorized expenditure is irregular.
Yes, it may be.
It may be.
Yeah, okay.
If we go on to page 115, please. The document entitled Terms of Reference will become relevant later, particularly in relation to what happened in Gauteng, but I understand terms of reference to have a technical or specific meaning. What are terms of reference in the context of this policy?
In terms of reference, one perhaps could be meaning your specifications, for lack of a
I'm sorry,
better
could
way.
mean?
Your specifications, for lack of a better way.
Oh,
in other words,
okay,
terms of
yes.
reference
Yeah, okay.
could actually, in the broader sense, could actually mean that.
Yes.
So if services, and I'm going back to the definition, are required in terms of any procurement engagement between the department and a service provider, one would look to the terms of reference to find specifications of those services that are required. Do I understand the position correctly?
Yeah, it depends on what procurement strategy we are using.
All right. So we'll come to that in due course. And then the phrase unsolicited bid is defined there on page 115. Let me ask you before we get there, do you understand there to be any difference between an unsolicited bid and an unsolicited proposal? Or are they the same thing?
In practice, they might be the same.
In any event, unsolicited bid is defined here as an offer, bid submitted by any person on his, her, or its own initiative without having been invited by the department to do so. The proposal then that was received by you, which we have discussed at the commencement of your evidence, was, in terms of this definition, I understand, unsolicited. We established that, I think.
It might well be.
It might well be. Are you saying it could have been solicited? I understood it to be a matter that didn't raise much controversy, certainly in evidence thus far, that the proposal submitted to you, which we discussed earlier, had not been solicited by the department.
Yes.
That's correct, is it?
Yes.
Then if we go over the page, please, to page 116.
116.
Under paragraph 4, employees to whom the policy applies, basically it applies to everyone in the department, as I understand it.
Yes.
And everybody must obey it. Is that correct?
Yes.
And then paragraph 5 refers to various governing prescripts, including the Public Finance Management Act. And over the page, on page 117, there are a number of other prescripts which are referred to and expressly which apply to a supply chain management within the department. Do you see that at page 117?
117, yes.
And if I may refer you to subparagraph B, it's 5.2b, on top of page 117. It reads, to meet the requirements as set in section 38 of the PFMA, the department will observe fully the 5 pillars of procurement set out in the general procurement guidelines. And they appear in brackets after that: value for money, open and effective competition, ethics and fair dealing, accountability and reporting, and equity. Did those 5 pillars apply, or did you regard them as applying in your department?
Yes, they do apply.
And if we could go through, please, to paragraph 8.2 on page 119, under the head value for money. Are you at page 119?
Yes, I am.
If I may read it, and then you can confirm whether I've read it correctly and whether it applied. Value for money remains the essential test against which procurement outcomes in the department must be justified. While not a criterion in itself, it is nonetheless the basis for comparing procurement alternatives and offers from suppliers in order to identify the one that meets the needs in the most cost-effective manner when all costs and benefits are taken into account, especially the quality of the product that will be delivered and previous experience with the supplier. The general point, as I understand it, is that value for money is, if not the most important criterion, certainly a very important one in any procurement process. Do I understand that correctly?
Yes.
Then if we look at the core principles under 8.3, they emphasize a number of principles that are reflective of the various constitutional and statutory principles that we've dealt with. Correct?
Yes.
Including 8.3a Roman 1, that the department is committed to ensuring transactions achieve the best net value for money outcome for the state. Again, emphasizing the value for money principle.
Yes.
And this may become relevant later as well, Mr. Mkesi, 8.3 subparagraph C Roman 1 obliges the department to observe the requirements of the Preferential Procurement Policy Framework Act of 2000. And there are a number of provisions there, at least one or two provisions that we may deal with later. You understand that to be the position? Again,
Yes.
you nod, Mr.
Yes,
Mkesi.
okay, sorry.
Then in paragraph 8.6 on page 120, refers to the AO, that's the accounting officer, that was yourself, I understand your evidence. The accounting officer reserves the right to maintain oversight over the implementation of this policy in order to A, ensure that the Director SCM executes this policy in accordance with the relevant legislative requirements. In other words, the right of supervision over Mr. Matlakala, as I understand it, was retained by the accounting officer yourself.
Yes. Okay.
And the right to maintain oversight was also in place, if one goes over the page to page 121, subparagraph C, to ensure compliance by all departmental officials to the SCM policy. And then in 8.7, the various duties that rested upon the Director of Supply Chain Management are set out. That was Mr. Matlakala, as I understand it. Is that
Yes.
correct?
Yes.
We could go through to page 139, please.
One, 139.
139, FS7, paragraph 12.13. Are you there?
Yes. I'm
That paragraph deals with unsolicited bids. And subparagraph A reads, the department is not obliged to consider an unsolicited proposal, but may consider such a proposal only if it meets the following requirements. Roman 1, a comprehensive and relevant project feasibility study has established a clear business case. And Roman 2, the product or service involves an innovative design. Or Roman 3, the product or service involves an innovative approach to project development and management. Or Roman 4, the product or service presents a new and cost-effective method of service delivery. And the paragraph continues under subparagraph B to talk of the unsolicited proposal. It seems that you're correct when you say that the terms may be used interchangeably. There's not much substantial difference between a bid and a proposal. Now, we are investigating that with the experts, but if necessary, we'll come back to you on that, Mr. McKenzie. But for present purposes, bids and proposals, the phrases are used interchangeably in this provision here at 12.13. Now, when you read the unsolicited proposal that we've referred to in evidence, did you consider whether it met the requirements in 12.13 subparagraph A?
What we normally do when we receive a proposal, and that's precisely the reason why you have a specialist in the department and why you refer a specific issue of procurement to the practitioner to determine what is the most appropriate way of procuring that specific need.
You will recall the passages in the transcript which were put to you earlier today, Mr. McKenzie. As I understood the position, there was an in-principle decision made by yourself to proceed with the procurement process. And for that purpose, you, having made that decision, referred it to Mr. Matlakala to advise you or to decide what processes must be followed to conclude the process. Do I understand your previous evidence correctly?
Yes.
Yes, all right. Now,
I'm sorry, is the answer yes?
Yes.
Oh, okay.
and if you look at 12.13 sub A, it's quite strict as I read it in any event, and you can comment if you like. It says the department is not obliged to consider an unsolicited proposal. So it was open to you, having received the proposal, simply to put it aside and take it no further. Do I understand the position correctly?
Yes.
But the provision goes on. It says you may only consider the proposal, or you may consider the proposal only if it meets certain requirements. In other words, unless the requirements in 12.13a, Roman 1 to Roman 4, have been met, you may not even consider the proposal. Do I understand the position correctly?
Let me try and perhaps put a perspective. The application of, or the use of, I'll call it an instrument that was used for this particular one, I admit that it was not the correct one. Now, in terms of what does the supply chain practitioner advise in respect of the procurement for that, I would say he applied an incorrect principle and not the unsolicited. So to me, there's no point in us debating around the issues of the unsolicited bid. While I understand what it says, but the application of was the problem. The application of when that proposal came, how it was applied, I would say, yes, indeed, it was an issue.
Well, let's, if we may, just try and summarize the position from your answer. I understood you to concede that Mr. Matlakala applied the wrong prescripts in this procurement process or advised incorrectly. Could you just explain that to the chair, please?
I'm saying when you choose, look, the 16.6A that we are talking about and the various others, unsolicited bids, etc., etc. We must not create an impression that they don't have an underlying competitive bidding, etc. All those particular issues.
Please look this side, Mr.
Oh, sorry.
Yes.
So I must address the chair.
We mustn't think that they don't have an underlying.
I'm saying we must not create an impression that the only way to satisfy the constitutional requirements is your conventional tender as we know it. All those particular issues like your unsolicited bid and so on, all of them underlying, and the underlying issues there is all of them, they comply with the constitutional requirements, transparency, etc., etc. Right? Now,
Is what you mean that the application of, is it Regulation 6? The application
Precisely.
of
Now,
that is part of the law.
It's
It's part of the procurement law. And if, I'm making another example, if you use a deviation, that is still part of procurement law that you are supposed to apply, and if you apply it correctly, there is no problem.
There's no problem. It's how you apply it. Now, I don't want to get into the debate about the unsolicited bids and so on. And
Yes.
so on. I'm saying
Yes.
a wrong, let me put it here, an incorrect application of the law was used when it comes to this particular issue.
Yes.
This is what I'm trying to say.
Yes, yeah. You say the law was applied wrongly,
Incorrectly.
incorrectly. Yeah, okay.
Well, let's deal with that because I'm not sure what you mean by the law was applied incorrectly. As a first step, would you concede, because it's pretty clear from the evidence that we've been given that the department could not have applied the provisions in regard to an unsolicited bid in respect of what was proposed to you on the 28th of May 2014 by Blackhead Consulting and Diamond Hill?
If, maybe no.
All right.
Maybe,
It seems if...
Or maybe Mr. Protos, can we start this way?
Yeah.
Because you said what you are prepared to say, the law was applied incorrectly. I think that's what you said.
Yes. I'm saying, yeah.
Now, maybe we should start by saying, would you elaborate on why you say the law was applied incorrectly? Maybe if we come from that angle, you give your own explanation, it's going to be easier.
Yeah, perhaps maybe we should try and simplify that.
Yeah.
You apply 16.6A where you should be applying
Something else.
something else.
Okay, no, that's fine. I think that may clarify.
Well, not entirely, Chair.
Yeah,
So
no,
I might have to go the long route.
No, that's
And I
that's
don't know
fine.
whether this is an appropriate time.
Oh, yeah, I think we'll have to take the lunch adjournment. We'll take the lunch adjournment now and we'll return at 2 o'clock. We adjourn. And you would say the correct one would have been which one?
Well, on hindsight, I will say the correct one will probably have been the unsolicited.
Unsolicited.
The unsolicited.
Yeah, okay. Yes, Mr. Pretorius.
Well, let's go back then to the department's supply chain management policy, which in fact, and I don't think there's much controversy on this point, mirrors the PFMA and Treasury regulations insofar as they deal with unsolicited bid. Let me put that to you. The provisions of your supply chain management policy would always have mirrored the legislation and the Treasury regulations. Would that not be the case?
Yeah, the provisions of?
The provisions of your supply chain management policy in the Department of Human Settlements would always have mirrored the provisions of the Public Finance Management Act and the Treasury regulations dealing with unsolicited bids.
Okay, yes.
That's correct, yes. All right, so let's just deal quickly then, because it does not appear to be too controversial from what you've said. If you would go to FS7, page 139, please.
139. Yes.
That's where we were before lunch.
That's where we were.
Yeah, that is where we were before lunch.
If you go to 1213A, that is the provision we were discussing before lunch, which says that you can only consider an unsolicited proposal if that proposal meets certain requirements, and those requirements are set out in Roman 1 to Roman 4 of paragraph 12.13a on page 139. Do you see those requirements?
Yes, I see.
Now, as I understand the proposal, and if you want to take me there or take the chair there, we can go there, but they did not comply. That proposal did not comply with those requirements, or certainly did not comply with all of them. We can go into the detail if you want.
Maybe with not all of them, but with some of them.
You say some, but not all.
Yeah.
Which ones did it not comply with?
Well, if you say around the issue of a business case, there was certainly a need. The product or service involves an innovative design. There's no element of that innovative.
There was no innovative design in the bid.
Yes.
Yes.
But it was necessary.
Similarly, I would understand that there was no innovative approach apparent from the bid, at least.
Sorry?
There was no innovative approach as required by Roman 3 in the bid. Would you agree with that?
Yes.
Yes. And then Roman 4, I do not understand the bid to have shown a new and cost-effective method of service delivery.
Well,
it has never been done. Sorry?
I'm sorry, Mr. Pretorius, isn't 3, 4, and 5, aren't they optional? I say that or after Roman figure 2 and or after Roman figure 3. In other words, is the position not that the first two, Roman figure 1 and Roman figure 2, are compulsory, but maybe if you don't meet Roman figure 2, at least you must meet Roman figure 3 or Roman figure 4. but you don't have to meet all four of them.
Yes, that's why I need to put them all.
Yes, no, I understood you to be, your question to be based on an understanding that they all have to be complied with. So I wanted to clarify that.
Yes. Well,
Is your understanding the same as mine?
yes, Chair.
But I accept that they need to be put to him, maybe one by one, to make sure
Well,
that there's understanding.
Maybe a different approach that I was adopting, but I think it has the same effect.
Yes, no, that's fine.
Because if there's no innovative design and no innovative approach, and it's not new and cost-effective, then none of the alternatives would apply. And I understand we're almost there, Mr. McKessie, that it wasn't innovative in design or approach, and it wasn't new and cost-effective. Can we agree on that?
Well, I don't know about the cost effectiveness of your.
I'm sorry, I can't hear you.
I'm saying I'm not so sure about the cost effectiveness. I would agree with in certain instances 2 and 3 perhaps, but certainly 1 there was a need for that.
Well, let's put it to you. Was there an innovative design apparent from the proposal?
The project was about assessment and ultimately phase 1 and assessment and audit, and secondly phase 1, the removal. So that was what it was about in the main.
Yes, but was there anything innovative about it? Anything new about identifying houses and assessing their condition? That was apparent from the bid.
I understood you earlier, and maybe I misunderstood you, and you must tell me if I misunderstood you. I understood you earlier to accept that Roman figure 2 was not complied with. Am I right?
Yes, I said so.
Yes, okay, all right. I think that's the answer, Mr. Procedural.
Yes, does the same apply to Roman 3, an innovative approach? That wasn't complied with. I understood you to say that, but I may be wrong. Correct?
Correct.
And Roman 4, the service presented a new, I stress new, and cost-effective method. Let's leave aside cost-effective for the moment. That's for later discussion. But was it a new method that was being proposed?
Certainly, maybe to us as the province it was new, because we use largely, or in the main, we followed the Gauteng route.
Well,
Because we did not know anything else.
Let's go then to the proposal.
But before we do that, Mr. Procedural, I just want to make sure. Roman figure 1, what did you say about it?
Well, I indicated that there was a need.
There was or there was no feasibility study? Roman figure 1 says there must be a comprehensive and relevant project feasibility study that has established a clear business case. Was there a comprehensive project feasibility study that established a clear business case?
As I've indicated earlier, we relied mostly on somebody else had done it already.
Yes.
And in these instances, and that is why I'm specifically referring to Gauteng, to say they have done it, and we knew that being the member of the same human settlement family, we knew that they have done it. And indeed, it was also part of the discussions that the MINMEC, this issue of the removal of eradication of asbestos. So we're merely following up in terms of what Gauteng had done.
I take it that when the policy refers to a comprehensive and relevant project feasibility study, it contemplates a document which contains the study. Would that be the same understanding that you have as well about that requirement?
I didn't, can you
Let me
repeat that?
let me repeat. When Roman figure 1
Yeah.
says there must be a comprehensive and relevant project feasibility study that has established a clear business case, I assume that what it contemplates is that there would be a document which constitutes that feasibility study. Would your understanding be the same, or
Yes.
would your understanding be that there need not be a document?
The studies around asbestos are there.
Are there?
They are there, you know, and in terms also the dangers and so on. I don't think that is an issue at this stage.
Yes.
Around the effects and the dangers of asbestos, and that they needed
Yes.
to be eradicated. And that's not. They are there. They are widely available.
So you would say that there was such a comprehensive
Yes, there is.
study. It may not have been provided by the entity that put in a proposal, but the
But the
study was
studies
there.
are there.
Yes,
The
okay.
information is widely available.
Okay, all
And
right.
as I've indicated as well,
Yes.
these discussions were continuing on at MINMEC level
Yes.
as well. So that information is widely available.
Okay, I just wanted to make sure that before we proceed further down the page, we know what the answer is in regard to Roman figure 1.
All right, well, perhaps understand one thing you said. You said you relied on what had been done in Gauteng.
What I'm saying is the removal and the assessment, the work in Gauteng had already been done. So Gauteng, I will say, was they had already established a principle in terms of the work that they have done already around.
There was a precedent.
There was a
in-
precedent already.
Yes.
Yeah,
Well, then what
okay,
was
that
new about the method of service delivery in Free State?
Sorry?
What was new then in the Free State?
Every township in the Free State has got asbestos.
I'm sorry, every township in the Free State has what?
Every township in the Free State has got asbestos
Roofs.
asbestos roofs.
Okay,
Okay, and coupled with the fact that in one of the State of the Province address, an issue was also discussed around the eradication of the two-roomed houses, which in essence also, those two-room houses also have asbestos roofing in the main. Now, as we speak, the province is incrementally also, incrementally also removing, eradicating those two-room houses because of the historical fact, in terms of those two-room houses, they were only meant for a specific population. And coupled with that, because all those two-room houses have got asbestos roofs as well. So we sort of tapped on what Gauteng has done to have a holistic approach in terms of one, getting rid of the two-room houses, and in the process also look at removing the asbestos both on the two rooms and on the four rooms and in all dilapidated houses.
The question remains, Mr. Makesi, what was new about the service proposed in this document, the unsolicited bid? What was new about it, about the service? You yourself said you had Gauteng as a precedent.
Well, Mr. Pretorius, I suppose what you are trying to push me on is on the issue of the unsolicited bid and whether there was anything new or not. And I think I've responded to that question.
Well,
Well, I wanted to ask that. I wanted to say, well, maybe first the question should be whether you say there was anything new, because I had understood you before, and I may have been wrong, that you were not saying that there was anything new, but I may have misunderstood you.
I don't understand, perhaps maybe the question of what was new.
Yeah.
Safe to say, this is within our mandate
Yeah,
as a department.
yeah,
It's part of the housing code. So it's part of our ongoing work in any event.
well, I understand that it might be part of your mandate. I think that's well established on the papers and in the evidence. But let me ask you then, if you go to 12.13,
12 point?
13 on FS 7139, that's where we are.
Okay.
You have that?
Yeah.
You see Roman 4 as being a requirement not of any other document, but of the proposal. You see that? The proposal may only be considered if it meets the following requirements. And then we go to 4. Now, this is your document in your department, Mr. Mkhezi. The product or service presents a new and cost-effective method of service delivery. Perhaps you could explain to the chair what new means in that context. It being your document.
Well, I suppose the new will refer to the method, and certainly the removal of asbestos is within our mandate.
Yes, we're not doubting it was within your mandate for the
within our
present.
mandate.
Mr. Mkhezi, we want to understand, or at least we would like to understand this side of the room, what you mean by it must be new, a new method of service delivery.
just your understanding, your own understanding of what this means. In other words, Mr. Pretorius is asking for your own understanding of what this part of your policy means.
Well, it might mean that it has never been done before. That's also new. Or it is done differently than the conventional way that it was done before. Yes, it might mean that. It might mean that it's a completely new thing. It has never been done before. But obviously, as you apply that, it must be within your own mandate. It's not something that is outside your mandate. Or it might be a different method
Of doing things.
of doing things.
Let's accept for the moment that it was within mandate. That's not a matter of dispute. The description you have given of a new method of service delivery, I would understand, is in accordance with the ordinary meaning of those words. There is, and you can correct me if I'm wrong, there is in this proposal at Pre-State 8164, nothing new or nothing different about what was done in Gauteng or what had been done before anyway. Would you like to look at Free State 8164?
Nothing, you said nothing new.
There's nothing new, nothing unprecedented, nothing that had not been done before. It wasn't new. As described by yourself.
Maybe if I can assist, you have said that Roman figure 4 at 12.13 means that the proposal comes up with a new method of doing things. Now, Mr. Pretorius is putting to you for your comment that in this proposal that was submitted, there was no new method of doing things that was apparent from the proposal. What do you say to that?
Okay. Yes.
You accept?
Yeah.
Okay.
So we don't need to go to the document then, for the moment at least. But let's go further. Let's deal with the National Treasury Circular. And to assist you here, we also have that document. It's at page 193 of the bundle that is in front of you. So I may be misleading you. FS 7196. This is a Treasury circular.
193.
No, 196, I'm sorry. This is a Treasury circular. It's dated 28 October 2004. That's apparent from the stamp at the bottom of page 196. And its heading is Implementation of Supply Chain Management. At page 197, deals with unsolicited bids, and I stress unsolicited bid. And what we're dealing here with an unsolicited bid, the Treasury Circular places some duties on an accounting officer in paragraph 2.2 on page 197. Do you have that? And it reads, if an accounting officer authority decides to consider an unsolicited bid, he or she may do so only if the product or service offered in terms of the bid is a unique, innovative concept that will be exceptionally beneficial to or have exceptional cost advantages for the institution. Let's leave aside exceptional benefit and exceptional cost advantages. We can deal with that later. But I understand that the product or service offered in terms of that unsolicited bid or proposal is considered by you to be not unique and innovative. Firstly, others had done it, and secondly, it was not new. Would you accept that?
Yes.
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 Sorry, you can't nod.
Yes.
I mean, you can nod, but you should also say yes.
Yeah, when you nod, the microphone doesn't capture the nod.
Yeah.
But your answer to that question was yes, I understood.
Yes.
And then B, the person who made the bid is the sole provider of the product or service. Now, given the experience of Gauteng, we know that not to be the case. Would you accept that?
Yeah. Yes.
And C would apply because we understand that there had been some strategic planning around removal of asbestos. You know that.
Yes.
All right. But let's then go to the National Treasury Practice Note 11 of 2008-9. That appears at Free State 7, 202.
What page are you, Mr. Procedural?
Free State 7, 2000
That's the same
sorry,
file.
Free State 7, 202.
202.
Yes. This is a document which appears on page 212 to have been issued on the 16th of March 2009 and issued in terms of Section 76 of the PFMA, Public Finance Management Act. You see that on page 212.
212.
Yes. And this is a practice note dealing expressly
Sorry,
with
can I
unsolicited
just-
proposals.
212.
We go back to 202, but the proposition I just put to you is at page 212, that this practice note was issued under the authority of Section 76 of the PFMA and was issued on 16 March 2009. You have that.
Yeah, I have that.
This document deals expressly and particularly with unsolicited proposals, and it appears as such on page 202. You have that. Under the heading Purpose, paragraph 1.1 reads, "This practice note provides precise guidelines for institutions dealing with unsolicited proposals stroke concepts. An unsolicited proposal stroke concept means any proposal stroke concept received by an institution outside its normal procurement process that is not an unsolicited bid. That is a submission that must be innovative, unique, and provided by a sole supplier." What we know is that the proposal that you received was not an unsolicited, it was received by you outside of the normal procurement process. It was unsolicited, correct?
Yes.
Yes, so if we go on then to 2, on page 203, there are set out the criteria for consideration of an unsolicited proposal. Again, the provisions of your supply chain management policy are mirrored here. 2.1, institutions are not obliged to consider an unsolicited proposal, but may consider such a proposal only if it meets the following requirements, and then the requirements we've just dealt with are set out. You see that? Those are the same requirements as contained in your policy, your departmental supply chain management policy.
Yes.
And then, if one goes over the page to paragraph 2.3. The requirement is that the unsolicited proposal must set out the following information in terms of the product or service offered. Firstly, a concise title and abstract, approximately 200 words, of the proposed product or service. We can debate whether that's applicable or not, but it's perhaps not necessary to do so. 2.3 on page 204.
I think Mr. Mufetzi, Mr. Pretorius is leaving both of us behind. I was still on 203 as well.
So we're on 204. Well, I am at least, Chair.
I'm there now.
Page 204. Are you there? Paragraph 2.3. The unsolicited proposal must set out the following information in terms of the product or service offered. Let's go immediately to subparagraph C, a statement describing how the proposal is demonstratively innovative and supported by evidence that the proponent is the sole provider of the innovation. Can we accept that that wasn't contained in the proposal that we referred to? Yes. D, for providing the product or service in sufficient detail to allow a meaningful evaluation by the institution. As I read it, at least, it should have the price of the product or the total estimated cost for providing the service in sufficient detail to allow a meaningful evaluation by the institution. Would you accept that the proposal didn't contain that information? There it seems that what is sought to be extended is an instruction to perform work which would have contained approved terms and conditions such as specifications, price, and the like. Do you understand it in the same way?
No, okay. My understanding here is obviously the instruction to perform work is the one that gives you the contractor to execute the work. But there will be a contract that says...
That's what you had in mind.
Yes.
Well, we have seen, you recall the phrase that we referred to this morning, terms of reference. We have seen the Gauteng terms of reference, but what we do know is that at least the terms and conditions relating to performance and the price in Gauteng were different from that entered into in the Free State. You're aware of that?
Yeah.
Yes. And so we know then that the
650 versus the 850.
I'm sorry?
That's what we are referring to.
The 650 and 80, 850, yes,
Yes, okay.
per unit. There are other differences, but I don't necessarily want to go into those unless you wish to. I don't think it's relevant. For the point that we make now is that I understand your evidence to be you wouldn't have looked at the documentation and the Gauteng to establish what those terms and conditions were.
Yeah, simply because of the voluminous, procurement documents are voluminous in them. And each one of us has got a role to do his or her work when it comes. I mean, the documents, I would have expected that from the supply chain in Gauteng and to have supplied by request, per request, of course, which is part of the due diligence, to say, please give us all the documents, from the advertisement and, documents, tenders, those who who, even those that were disqualified, because you have to have that information. You have to have the information as if it is you who is doing, you know. And that information by itself will be voluminous, because then you also have to look at various reports through different committees. So you have to request all the information from A to Z.
I'm not sure that it would have been too difficult and too voluminous a task to simply establish what the price per unit was in Gauteng, would it? Simple question, what was the price per unit in Gauteng?
No, the unit in Gauteng was 650 a unit.
But what I'm saying is that it wouldn't have been too difficult to establish just that fact before entering into a contract in Free State at 850. I
think what I've indicated previously, Mr. Pretorius, you know, I said, you know, after the fact, I asked 3 questions. And one of them was, did you get permission from Treasury? In other words, did you make, as a supply chain practitioner, to account up to Treasury, did you make a
Look this side again, Mr.
Sorry?
Speaker.
Okay, sorry, Chair.
You asked 3 questions.
I asked 3 questions. One of the questions is, did you request and make motivation to Treasury to, you can vary the price, but it should be provided Treasury has approved and you have so given the motivation to Treasury, because those are the 3 questions that I asked, and one of them was that. So it didn't happen.
When you asked Mr. Matlakala, did you seek the approval of Treasury to adjust the price? What did he answer?
Well, he couldn't respond. You know.
He couldn't respond.
He couldn't respond.
When did you ask him?
You know, at the point when remember there was a finding that the contract, in other words, the contract was irregular, and one of the issues that was raised around was precisely that particular point, that you could not provide a motivation, a proof that there was a Treasury approval.
Yes, but the question is, when did you ask him? And when did he give you this false assurance? Upon
when there were issues with the contract. In other words, when there were issues, upon the finding, let me put it that way.
Of the public protector?
No.
What findings?
The finding by the AG.
All right. Well, we haven't really canvassed that, but were you aware that the Auditor General in the Gauteng province had declared the Gauteng contract, asbestos contract, invalid?
I became subsequently aware of that particular issue.
And were you? When did you?
At the time when this participation was happening, it had not been declared.
Yes, not the Gauteng contract, but ultimately the Free State contract was also declared invalid by the Auditor General in the Free State.
By extension. In other words, if it is irregular in Gauteng, it can't be regular with you.
All right. But I understand that, well, when did you become aware of that finding? At the time it was made? You must have, surely.
The audit of I think it was 2015.
Well, do you know that payments were made pursuant to the Free State agreement, payments were made after the Attorney General, not the Attorney General, the Auditor General had declared the contract invalid, whether by extension or not.
Yeah, but the work had already been done by that time.
But, all right, well, let's just, let me just take it step by step and take a deep breath. In the Free State, the Auditor General declares the contract invalid, correct?
Irregular. But I don't know whether it means the same.
And you become aware of that?
Yes, we become aware through the audit that this particular contract is irregular in Gauteng, and therefore it cannot be regular.
Is it correct that after you became aware of this fact, payments were still made to the service provider in relation to the Free State contract?
Because the work was done.
Well,
Already.
is that,
I didn't hear that answer.
Okay, I'm saying the work was already done.
Yeah,
well,
okay.
let me
Now,
ask for,
What you could not continue with is the second phase
Yes,
of the contract.
okay.
The only thing that we could, because ordinarily, Chair, if something is declared irregular, right, there is a certain framework that we'll have to follow, right? What happened? Who was responsible? For example, and whether there was value for money that was received. Now, the only thing, and who's responsible, obviously will lead to certain consequences for that particular individual or individuals that caused the irregular expenditure, because you have to investigate and so on and so on. Now, in this instance, work was done. Completed. Now, the question is value for money, which is a point of contention even right now. You'll recall also that there was a case or a judgment which was sponsored by a political party. Now, I'm aware that it was not, or perhaps we're informed that it was what was decided there was not on merits. In other words, whether the contract is irregular or not. But part of what was in that particular judgment, which perhaps maybe for people like ourselves created a confusion, was a finding that says there was no overpayment, because that was also part of the issue. Also, whether we paid, the department paid too much for that or not. Now, that in that judgment, it says there was no overpayment, perhaps on probabilities. Now, if you have that, that assertion that says there's no overpayment, it sort of in a way suggests that value for money was received. So what remains is irregular expenditure has occurred. Who's responsible? Then we have to do that particular investigation to say, okay, how did it occur? What systems are we going to put in place to ensure that there's no recurrence of that in the future? Now, so those payments were made on those in terms of that understanding. That says at the time value for money was received. However, subsequently, then came in the investigations by the public protector, which then, as management, were of the view that, instead of continuing, there's an investigation that is going on. So let's wait for the outcome of that particular investigation, because it is done independently, and see to what extent can we apply the consequence management thereafter. I think that has happened now with the advent of the release by the public protector of the report, which is another leg, because we thought we shouldn't do it internally, because the alternative was to do that internally. But now you run the risk that if you clear individuals, for argument's sake, and the public protector comes in now at a later stage and find against, we'll then have to revert back. So the consequence management of that action is now happening because of what the public protector is running, and I think it also applies to me as an accounting officer, and this is what is happening now. The other part is okay. Thank you.
Okay. Mr. Pretorius.
The position is as follows then. The Auditor General in the Free State declares the contract, the asbestos contract, irregular or invalid. You continue to make payments nevertheless, and you say the reason you did that was because the work had been done.
And there was a judgment which said there was no overpayment.
Yes.
I think he gave those reasons.
Yes.
But yes, I understand that, but that we can investigate as to whether that is...
But also, Chairperson, I think, if something has been...
don't put it on.
Sorry. Yeah, if something has been declared irregular, depending on where it is, let's make a simple example. I ask you to build a house, you complete the house, and after you have completed the house, I have to pay you. The auditor comes and say it is irregular. Right? Now, you can't say I'm not paying you and keep the benefit. And those are some of the considerations that you have to take into when you decide to. Obviously, you cannot continue with the contract. Okay. The contract ends there, and we could not also continue with a second phase.
All right. I don't want to debate the law with you, but the principles upon which an enrichment claim, which is the legal term, would be calculated would be entirely different from the contract. If the contract is declared irregular, my understanding of the law is that the contract cannot therefore be enforced from either side. But if a party has benefited unduly from the implementation of a contract, there may be circumstances where that party may still recover payment, but the principles are entirely different. And would have resulted in a different financial outcome. But I don't want to debate the law with you in that regard. We know the facts. Let's just go to another letter, please. Before we go on, when the public protector issued her report, payments were stopped. Correct? Correct?
Is that a yes?
All right,
Yes,
let's go to
and
another
the reason being,
Yes.
in the main, right? One of the issues that was mentioned in the public was value for money, right? And in the main. Now you don't continue when there's already that particular finding of value for money.
You don't continue when?
I'm saying the reason being, one of the issues that was raised by the public protector was value for money. So
Yes.
it needed also to be exhausted indeed to find out indeed is this correct or not correct. And it's also going to come out perhaps because there has been a proclamation on this matter by the SIU, which I think in their mandate, that's also what they have to determine.
You say value for money was one of the issues raised.
One of the issues.
Yes, well, I must just say for the record that if the contract was invalid as a result of anything found by the Auditor General in the Free State, the same or similar principles of value for money, unjust enrichment principles would have applied. But again, perhaps we shouldn't debate that law. It's quite complex.
But, when an irregular expenditure has been determined, there's a process, what they refer to as the write-off.
There's a process?
Of write-off.
Yeah, of write-off of some debts.
Of the irregular expenditure, right? And you also go through that particular process. Now, the AG will never allow you to write that off if he's not satisfied with what we have done. Now, he has, it has been written off, basically. So, I don't know as to, because the determination of the value for money as well is also the part of whether you will be allowed to write off that particular irregular expenditure or not.
Perhaps you could answer this question and then we can move on. In terms of all the regulatory prescripts that would bind an accounting officer, if a contract is declared irregular or invalid by an Auditor General, as happened in this case, what are the duties that rest upon an accounting officer?
Okay. The first thing is you investigate. You investigate, okay, as I've indicated, what happened, right? Who is responsible? Did we receive value for money? Because sometimes terminating the contract can actually be very costly in certain instances. I'm not saying in all instances, but there might be, particularly in construction. You can actually end up with a bigger bill than you anticipated, simply because you chose to write off the contract. Also taking into consideration that, your own internal issues cannot be, okay, I suppose I'm talking to a judge and a lawyer here, but your own internal issues cannot be at the prejudice of external parties who are not part of your processes. They have delivered what you asked for, and then you come up at the later stage and say, no, this contract is regular, it's irregular, and therefore I'm not going to pay you, but you keep the benefit. I understand. Look, I don't want to, as you say, Mr. Pretorius, I'm not a lawyer, so, but that's basically sometimes where you have to, apply your mind in terms of whether you have to not to pay, and if you are not going to pay, why are you not paying if you have received the value, and what informs that?
Let's avoid legal terminology then, because it seems to me that the principles that you've been dealing with now are reflected, at least to an extent, in the law. But let's leave the law to one side. As I understand your proposition now is that once you had learnt that the contract was irregular, you would have investigated whether there was value for money received by the department for which it should have paid or should pay. Do I understand the proposition correctly?
Yes.
Did you say yes?
Yes, I'm saying you investigate and what happened.
Yes, and particularly under the heading value for money. Because as I understand your proposition, if you've received value for money, you should pay for it.
Yes.
Did you investigate whether the department had received value for money?
Yes, we obviously we use the internal expertise to say, okay, fine. In respect of this particular project, was the work done as it was supposed to have been done?
There are two different questions, Mr. Mkesi. The first question, and what you have been speaking about, is value for money, not whether the contract, the performance under the contract was carried out. The question is value for money, because remember the contract is now set aside, it's irregular, so we're now looking at value for money. Did you investigate whether the department had received value for money?
Yes, we did investigate whether the
Who did that investigation?
The project management unit did that investigation.
Did you?
In terms of the terms of what was supposed to happen, and so that we did.
No. Once again, I'm asking about the prospect, or not the prospect, the concept of value for money which you have just raised. Did you ask for an investigation to be conducted when it was drawn to your attention that the contract was irregular, to be conducted into whether the Free State Department had received value for money, as opposed to whether the terms of the contract had been carried out?
Mr. Pretorius, I think I've answered that question. I said we did. You might not agree in terms of what has transpired perhaps right now, Chairperson, to say, I don't think you did.
Was this investigation carried? I'm sorry, I interrupted.
Let him finish.
In the normal course of events, you know, when an irregular expenditure happens, that's exactly what you did. And the AG will never allow you, because they will also do independently, of course through a sample basis, because it's not about, they sample their investigation as well, to say, fine, was, you know, on a basis of a sports thing. If for any other reason they are not happy around what we did, they will not allow that to be written off. They will not allow that irregular expenditure to be written off. So maybe not to your satisfaction, I don't know, but we did.
Well, the question that arises out of what you have said, Mr. Mkesi, let's take it step by step. When you learnt as accounting officer of the fact that the contract had been declared irregular, right? You, as accounting officer, must have been concerned having received that information, surely.
Okay.
Yes, right?
Yes.
What was important to the department and particularly yourself in regard to whether further payments should be made was whether the department had received value for money.
Yes?
Did you ask anyone to investigate whether the department had now received value for money?
As just said, we did, all right?
Who did you
Number
ask?
two, no, the production, the project management unit, and the head of the project management unit is Mr. Makep. But coupled with that, we also had this court judgment, which in a way suggested that there was no overpayment, because that was also the concern, to say we might have overpaid in this instance.
All right.
And it was also a matter of contestation in court as to whether we did or we did not. But, you know, the court did not pronounce itself on whether a contract was irregular, and that was not the issue. But they did pronounce on that particular issue.
That court judgment, you could give us the reference, I presume.
Yes, that's how I understood it.
Right.
At
Well,
that.
the investigators may ask.
And also internally, got assurance from, you know, from the legal division that indeed it basically says we did not overpay.
Well, the evidence before the commission to date indicates that there was a gross overpayment. But let's put that aside for the moment. I would like to interrogate that judgment, and perhaps we could get a reference from your attorneys in due course. But the question I have is, you asked the project management unit to investigate the issue of value for money. Did they provide you with a written report? Yes.
Yeah, normally what will happen is that because the preparation we would have a register of all the irregular expenditures that have been identified. Okay. And then there will be a preparation on those irregular expenditures that we that we have been able to resolve, and this one included. And then there will be that report that says, which we can also make it available to the commission around how that was written off.
Yes. Well, I'm not sure whether we're necessarily talking about the same report, but I understood your evidence to be that as an accounting officer, you would have received information that the contract in the asbestos project was irregular. You would have asked your project management unit to investigate whether you had received value for money. And my question is, did you receive a report pursuant to that request?
Yes.
And that report, was it in writing?
It was in writing with all other identified irregular expenditures, and not only that.
You see, the question I have, did you, in this particular case, ask the project management unit to report to you in relation to whether in this particular contract there was value for money? Did you make that request? Or are you relying on a general procedure?
In every irregular expenditure, value for money comes into play, in all of them. Not only the asbestos one, but in all irregular expenditures that have been identified, value for money is always.
Yes. Is that a practice that exists?
Practice. It's a practice.
Well, I'm not asking about a practice. I'm asking you about a particular request arising in the particular circumstances of this case. You receive a report that a contract is irregular. You know that certain payments may still have to be made. You then decide that the value for money is an important consideration as to whether these monies should be paid or not. And I'm asking you whether you requested your project management unit to give you a report. You say yes. Now, I'm not talking about the practice that exists in relation to all irregular expenditure. I'm talking about a particular report in a particular circumstance. Did you ask for such a report?
Yeah, the report, what happens is that in a particular year, there will be an issue that says the following contracts or the following expenditure are irregular. Some are easy to resolve, some not. Now, those that are easy to, or those that have been apparently resolved, then there will be a one report on all of those particular irregular expenditures.
And that happens
and that's how they've been treated, whether it's the right thing to do or not, but this is how it has been done. And that information will then be made available to the Auditor General in terms of whether he agrees or not.
No, I understand that evidence.
So I don't know what more I should say in this particular
well,
issue.
perhaps just deal with the question,
Okay,
Mr. McKessie.
okay, Mr. Procedural. So maybe part of the problem is that at some stage or another on both sides, I think, the one starts talking before the other one finishes. So let's try and avoid that.
Right, point taken, Chair. But it's necessary to be laborious over this issue, I'm afraid.
Yeah.
You've referred, Mr. McKessie, to a practice that exists in relation to a report or reports on all irregular expenditure. That would happen regardless of whether you instructed a particular report to be provided for you. Do I understand it correctly?
I don't know why you want to single out this particular one to say it should happen differently.
Okay, let's put the question this way. Is it true that when there is irregular expenditure, there will be a report dealing with irregular expenditure without necessarily you instructing that such a report should be prepared? In general,
that happens as a,
as a practice.
It must happen. It must.
Yes.
That's what is required.
Okay, yeah. So your answer is yes.
Yes. Now the question is, who is in the?
Hang on.
Okay.
Yeah, don't go to the next question. So the position is that if there's been irregular expenditure, there will be a report. You don't have to instruct particularly that a report be prepared because it's a practice or it's required. All concerned know that it's required. Is that right? Yes, okay. Now, Mr. Pretorius, I think that clarifies at least part of your question. You have a follow-up question, I think.
Yes.
Yeah.
So I understood you to say now in this series of questions, Mr. McKessie, you said in this particular case, you asked your project management unit head to give you a report on the issue of value for money in the asbestos contract. Is that correct or not correct?
Because they have to do it because it is.
Hang on, Mr. Moketsi. Hang on. At this stage, you just need to confirm whether you did instruct a particular unit to prepare a report for you on whether there was value for money in this contract. Is that factually true?
Yes.
Did you do that?
Normally, what happens? We have a committee which we refer to as a irregular expenditure committee. Okay.
irregular expenditure
It's a
committee.
regular expenditure committee. I'm not
That's
part
for the department.
yeah, I'm not part of that.
Yes.
Because the reports that comes from there will then ordinarily come to me. Right?
Yeah.
Now, all those identified irregular expenditure will then go to that committee.
Yes.
Okay? And they will be deliberated there. It's got a chairperson and so on. But the key players in that irregular expenditure will be the CFO and
Yeah.
and some of the senior managers.
Yes.
Okay. Now, out of that will then come a report
To you.
on every irregular expenditure that has happened, right? To say, okay, this particular one, this is how we are going to deal with it. This is how it must be dealt with.
Yes.
With those recommendations.
Yes.
Like,
And included in that report.
there will be minutes on that and so on. Yeah.
Okay. Included in that report would be the topic of whether there was value for money in each case where there was irregular expenditure, or would it not be like that?
Yes, there will, in certain instances, it's easy to determine whether there was value for money
Yes,
or not. But in
yes.
certain instances,
It's not
you still need a technical unit
Yes.
like the PMU to so go out and find out whether there was
Value for money.
value for money and so on.
But would it be correct to say that report that comes from that committee, that the report that comes to you on irregular expenditure, would it be correct that it has to address that issue of value for money? Whether it says, yes, there was value for money, or no, there was no value for money.
It has got to address.
It has to address that
It has
issue.
got to address that issue.
That issue.
And, you know, in this particular instances, I'm not saying, you know, value for money, etc. I don't know at this particular point. I cannot, with conviction, say that.
Yes.
Right? Because you know, we relied originally on that court case, but there have been subsequent investigation thereafter, and now the
Public protest.
the SIU, I think that will settle it at some to see.
Yes, okay, no, let's stop there. So as I understand you, there is a committee, an irregular expenditure committee that looks at all irregular expenditure within the department.
Yes.
And that committee interacts with all role players affected by irregular expenditure, items of irregular expenditures in the department.
Yes.
And they prepare a report that comes to you. And one of the issues they must address in that report in regard to each contract is whether there was value for money. Even without you saying anything, they know that that report must say whether there was value for money or there was no value for money.
Yes.
Yeah, okay.
And is it on the strength of that report, Mr. Mkesi, that you or the department decided that payments should continue to be made to the service provider in the asbestos project?
On the strength of that, plus, as I've indicated, on the
All right. So
on the order.
So is it fair to say then now, with your recent answers, that in this particular case, having received a report from the Auditor General in the Free State that the asbestos contract was irregular, you didn't, of your own initiative, cause an investigation into value for money to be made? You didn't do that? You see, what the chair has made very clear, Mr. Mkesi, is that this is a practice that occurs regardless of whether you intervene in any particular case or not. All irregular expenditure is examined by the committee in the department, and it will then report to you without your initiative having been taken in any particular case, correct?
Yeah, and the AG might agree or disagree with it.
Yes, no, but my question is, earlier I understood you to say that in this particular case, you approached, at your own initiative, you approached the project management unit, and you asked them to give you a report on this particular case as to whether there was value for money. Is that correct or incorrect?
No, the issue of once a regular expenditure has been identified, it's practice, because if you don't deal with it,
Yes, hang on, Mr. Matsedi. We know now what the practice is, you have told us. Okay. Mr. Pretoria's question is whether his understanding of what you said earlier is correct. And his understanding is that you said earlier on that you had asked a particular unit, I think project management unit, to prepare a report for you in regard to this contract on whether there was value for money. So your answer should be, yes, you understood me correctly, or no, you did not understand me correctly.
Chair, okay, let me put it this way. Every irregular expenditure, I asked the responsible, because we said in...
Okay, I'm sorry, just repeat that.
I'm saying in every irregular expenditure that occurs in the department, I asked the relevant user department, which has got the expertise on, to investigate that, because it's also part of, we have an audit action plan, right, that will identify specific areas of concern and so on, to say, okay, this is what the age is, this were the findings in that particular year, and in those findings, one of them would have been irregular expenditure, and this is how it is being made, right? Now, all those issues that have been raised on, we then put that in terms of the action plan and say, right, you do it. Who, the monkey is on whose back? It is on this particular one, it's you. On that particular one, it's corporate services, for example, if it's something that involves issues of employment, which were not done properly.
Okay,
so it's and this is what I'm trying to say when the AG has finished or has done with this report, we take that particular report, we put it up in a form of an action list that says who's responsible for what, and that will also have included this matter.
Okay, Mr. Mukherjee, it may be that it's been a long day, and you are the one who have been asked questions the whole day, but it's a very narrow question. Forget about what normally happens. Mr. Pretoria's question is, in regard to this case, is it correct that you said earlier on that you instructed or asked the project management unit to prepare a report and tell you whether there was value for money? Is his understanding of what you said correct? Did you say that or not earlier on? Or are you not sure?
Yes, as you say, it's a long day. How we because I'm trying to explain by saying every year, right?
Yes, but I don't want you to explain now. I just want you to try and remember whether you did tell me that in regard to this case, you asked the project management unit to prepare a report.
And so it's on all other cases. I don't want to And so is on all other cases where the
Yes,
expenditure
yes,
has occurred. That
but-
will happen. To
No,
say,
no,
okay,
no.
this is yours. You know, this
Yes,
is what I'm
but-
trying to say.
But you see, the question is not about other cases.
Okay,
Yeah,
yes.
so in this case, you did?
Yes.
Okay, all right, thank you. Mr. Pretorius?
All right. Just one more question then on this issue, Mr. McKessie. Apart from the system you've described that was in place, whereby all irregular expenditure is examined in relation to value for money and other topics, and a report is presented to you. Apart from that, was there any other specific request by you to the project management unit to report in this particular case?
I'm not asking you the same question, please.
Okay, the question is whether, with regard to the project management unit,
Yes.
was there any other request you made to them in regard to this case, other than the request that they must prepare a report which would deal with whether there was value for money? Is there another request that you
Another
made?
report.
Whatever request in relation to this contract, is there another request you made to them in relation to this contract that you can remember?
There is the chairperson, the request happened in the ordinary course of business, and it was once, it was
Yes.
report with all these others submitted to the AG to say, look at whether you are happy with what we have done, and so on, and then particularly for the write-off, and intrinsically that is the value for money. Now, if in certain instances the AG has refused to write off in certain and has requested us to do further work. In other instances of irregular expenditure, he has instructed us to do other work, to say, I'm not happy with this, and do some few tests and explain why he's not, why they're not happy. And then we had to do other work. In certain instances, we also had to, particularly when it comes to irregular expenditure, that because we had instances where we had to deal with irregular expenditure of 2010, 2011, and we had to outsource that part. So I don't know what more I can say.
Yes, Mr. Pretorius, it may be that it may be that you need to be more specific to say, did he request APC? Then
Yes,
maybe
well,
that might help.
Let me just do it once, or attempt to clarify once more, Chair. You've described in detail, Mr. McKessie, to the Chair, a system that was in place whereby all irregular expenditure is investigated from various points of view, including value for money, by a committee, and you're not a member of that committee. That routinely happens whether you instruct them in a particular case or not. Am I correct? There's a standing practice and set of instructions whereby irregular...
I think don't go back to it, Mr. Pretorius. It was clarified.
Okay?
Yeah.
Is that correct? Yeah. That's correct. Well, now the question I have is, apart from that process, which happens in any event, whether you initiate it or not, did you, in this particular case, when you received the report from the Auditor General, go to your project management unit and say, I want you to investigate this particular case as to whether there was value for money in this particular case? Please give me a report.
No, I don't want to say in this particular case and separate this particular issue to the others that we are doing.
Yes,
which are of similar importance.
Yes, okay, Mr. Mokhetsi, I think we've been along that road. The answer that Mr. Mokhetsi gave earlier on was that he did give such an instruction in this particular case, but he did say that he does it so in other cases as well. But in this particular case, he said he did give. Yeah.
Let's let the record, it'll be an exhaustive read, but let the record be read and we can decide what it says.
If I misunderstood him, I'm sure we'll pick it up, yeah.
Right, perhaps you can go then to 8, FS 8 at page 176.
I mentioned, for what it's worth, that we are 5 minutes away from finishing an hour. We can stick to that, or we can go to 1:30 and stop at 1:30, if we
Chair,
all agree.
I had a cordial discussion with Mr. Mpofu in the break.
Yeah.
And our understanding of the arrangement was 5 o'clock.
It was 5 o'clock.
5 o'clock. So I think.
Well, it's now 5:15.
No, I understand that. So
Oh,
we've
you think
conceded
we've
that
gone
point
beyond?
already. But I'm not sure we're happy to concede yet another extension.
Okay, no, I understand why I thought that what I said was the hour would be calculated from 20 past when we came
no, it
back.
was-
But it's not an issue.
No, I've received advice from behind, Chair, that your interpretation was correct and that we were clutching at straws. But we're happy to settle for 20 past, Chair.
Yeah, okay, all right then. Okay,
If
you
that's
may
okay,
continue.
I mean, if you insist, Chair, obviously,
No,
to be serious.
No, I just wanted to make sure, because 20 past might be seen as an awkward time to stop. I thought in case you say, you all agree, let's finish at 1:30, I'm quite happy that we do that.
20 past is not awkward at all.
I won't insist on going beyond that, because you are the only one standing, Mr.
Yes, well,
Pretorius.
only one left standing.
Okay, so we'll stop at 20 past.
Thank you, Chair. But to be serious for a moment, if you want to continue.
No, it's fine, it's fine.
Mr. Mkesi, if you would go to Free State 8, FS 8 at 176, please. That is a letter that refers back to your letter of 15 July, which we spoke about earlier. Remember that spoke about an instruction to perform work.
Page 176 of
FS
bundle
8.
FS8.
You have that?
It's a letter from Mr. Dirks to you. You have got it, yeah.
It's dated the 4th of August 2014, and it appears to refer back to your letter of 15 July, which we've already discussed. Now, here she says, request to appoint a professional resource team. The second paragraph reads, I hereby confirm my decision taken on 21 July 2014 that the Gauteng Department of Human Settlements granted approval in terms of Treasury Regulation 16A 6.6 for the Free State Department of Human Settlements to participate in the contract arranged by means of a competitive bidding process from the database of the Gauteng Department of Human Settlements for professional resource teams where Blackhead Consulting Pty Limited was appointed from. That appears on the face of it to be referring to a panel arrangement. Do you agree with me?
On the face of it,
Yes.
you say it appears to be from a panel arrangement.
Yes.
Okay.
You agree? Yes. Yes?
Yes.
On the face of it,
On the
appears
face of
so.
it, yes.
On the face of it. And once again, at this stage, references to Blackhead Consulting Pty Limited, not to any joint venture or other entity. You see that in paragraph 3.
Paragraph 3. Yeah.
You see that? She's giving her
The
approval.
paragraph that starts the approval, is that the paragraph that starts with the approval?
The approval is subject to the conditions that Blackhead Consulting Pty Limited.
So that's the paragraph that you are referring to?
Yes.
Okay.
She's referring to Blackhead, not to the joint venture.
Yes.
Correct. All right. Let's go on then to a letter that was written to Mr. Sodi by yourself on the 11th of August 2014. Perhaps we should deal with this letter and then bring proceedings to a halt, Chair.
Yeah.
What page is that?
It's at page FS8, 179. This is a letter dated 11 August 2014. It's addressed to the CEO, Blackhead Consulting Pty Limited, and it concerns the appointment of Blackhead Consulting Pty Limited for the asbestos eradication program in the Free State province. And paragraph 1 reads, and this is under your hand, Mr. Makesi, the above has reference to the concurrent approval by the Gauteng Province Department of Human Settlements dated 4 August 2014, the letter we've just referred to, regarding your participation in an agreement currently secured by them, and it will be appreciable, you say, if you could confirm in writing the following. 1, you formally agree to participate and extend your services to the Department of Human Settlements in line with terms and conditions of their IPW instruction to perform. Now, just to put one question for the present, Mr. Makesi, it seems that on the one hand, Ms. Diedrichs was talking about a panel arrangement, which we know cannot be extended or participated in. On the other hand, you're talking about an instruction to perform work with particular terms and conditions of contract. Is that observation a correct one?
No, my understanding is that there was a contract. There was an existing contract in Gauteng for Blackhead to do this work.
Don't lower your voice
Sorry.
too much. Don't lower your voice too much.
Okay. Chairperson, my understanding was that there was a contract, an existing contract with Blackhead in Gauteng, which we participated on. You know, the like-for-like issues that I mentioned earlier on. Now, for you to start doing work, it's one thing to say you have a contract, but in order for you to be able to start doing, you have to wait for, there must be an IPW, an instruction to perform work. And that's what you wait for. You can have an appointment and so on in the contract, but then you have to also wait for the IPW.
Yes. Well, that seems to be in your understanding, Ms. Makesi, but it doesn't seem to have been the understanding of Ms. Diedrichs. Let's leave that aside for the moment. The point about the instruction to perform work, that wouldn't have been concluded after a competitive bidding process. You agree with that? But you looked at the documentation.
That wouldn't have
been concluded as a result of a competitive bidding process. Those terms and conditions were unilaterally imposed on the panel by the Gauteng department. Did you know that? Or had you looked at the documentation, you would have discovered
which also suggested, you know, my earlier point on to say, if the documents have been requested, you could have picked up.
If the documentation had been examined, as you say,
Yes.
you would have discovered that the instruction to perform work was not the result of a competitive bidding process, and therefore 16A couldn't have been applied. Perhaps we could take it that far for the present. Chair.
Maybe let me just ask this question. Was your understanding at the time that Blackhead Consulting and Diamond Hill made a proposal to the Free State Department?
Can you repeat that, Chairperson?
Okay.
I think I missed something.
Yes. Was your understanding at the time that Blackhead Consulting and Diamond Hill made a proposal to your department, was your understanding that Blackhead was still continuing with the work or with some work in the Gauteng Department of Human Settlements? Or was your understanding that they had done their work and finished it?
No, my understanding was that they have an existing contract. There's work that they are doing in
In
Gauteng.
which would explain why Ms. Didericks made the point that Blackhead's commitment to be involved in the Free State should not
affect.
negatively affect them.
Yes.
The work in
Yes. And
Gauteng.
that's why you are required also to
get approval.
To get approval and get
Yes.
that undertaking.
Yes, but if at the time they made the proposal, there was the proposal to the Free State Department, there was no existing contract for work, but there was simply an appointment to the panel, then that would not justify extending any contract because there would be no contract to do work. There would simply be an appointment to the panel. Is that right?
The panel is not a contract.
Yes, that's what I'm saying, that in order for there to have been an extension or participation in a contract by the Free State Department, then the contract for work for Blackhead in Gauteng had to be in existence in the sense that they were still continuing.
Yes, it had to be in existence at the time.
It should not have expired. It should not have, they should not have finished the work.
Yes, in other words, the contract should have been valid.
Yes, should have been continuing.
Yeah. Forget about whether it was irregular or not, but there must have been a contract.
Yes, yeah. Okay, no, that's fine. Okay, we are going to stop here. I must thank everybody for your cooperation. I think we made a lot of progress. I think everybody was cooperating. We made a lot of progress. I think next time we'll be able to finish. But it's been a long day, particularly for Mr. Pretorius and Mr. Musegi. Mr. Pretorius because he was standing, Mr. Musegi because he was answering questions. But thank you to you, Mr. Musegi. Thank you to Mr. Mpofu and the legal team.
Thank you.
And to Mr. Pretorius and his team that we have been able to go up to this time and cover as much as we have. So another date will be determined. As indicated, it may be that it will be an evening session, starting at 4 o'clock or 5 o'clock. I understand everybody wants to cooperate to make sure we can finish. Thank you very much. Just for the sake of the public, on Monday, the commission will hear evidence from Ms. Thomas, the former PA to Ms. Nomvula Mokonyane, about Bosasa issues. We adjourn.
Thank you.
If you want to speak about that.